I am now going to turn it over to our co-host, Aaron, from over at Access Management, to say a few words about the great organization and herself. Aaron, take it away, please.
Awesome, awesome. Thank you guys very much. Thank you, Alan and Jeff, for setting this up. And thank you all for taking the time to join today's call. My name is Erin Poirier, and I am the new development specialist here at Access Management. While my role is a community manager focusing on helping new build communities get set up for success, Access Management does provide a full range of services for all HOA, condo, and condo hotel communities, regardless of size or style. Our services include lifestyle community support, realty services, property management rentals, food and beverage services, all rooted in the foundation of hospitality. So we're here to support you in your communities. Feel free to reach out to us at any time. Jeff shared a wonderful link for us, but there's also a phone number at 407-480-4200. And with that, thank you very much again for attending. I'll turn this over to our wonderful host, Alan, with K. Bender Rembom.
Thank you. And again, thank you to Access for being here with us today. It definitely helps to make sure that, your clients in particular are taken care of here. I know that there's a lot of information that we're going to go through, but I'm just going to go through some information about the firm very quickly. We've got 23 attorneys, 3 in my office, 8 who are board certified in community association law, including myself. This is really all we do. So if you have any issues that are involving your community, and generally speaking, primarily with respect to representation of the community, we'd be happy to hear from you, happy to help to the extent we can. And I'm going to resize this real quick, and then we will get started very quickly. The only other thing that I wanted to point out is, when you have those issues come up, it's not just community association issues. It's also the construction issues that pop up in an association. Literally anything pertaining to your association is what we do. It's what we've done for over 30 years. Not me personally for over 30 years, but in general. And we'd be happy to help. So we've got, as you can see here, hopefully 200 plus slides to get through. Good for you guys. We've got 2 of those that are only our information. You'll have these slides at the end of the presentation once you complete that survey that Jeff mentioned. So you will have access to this. Hopefully you'll be taking notes throughout to the extent you need to, but I'm going to go ahead and get started without further ado. Moving on, why the heck are we here? Well, the Florida statutes say that you need to be here. Within 90 days after being elected or appointed, the newly elected directors need to sign a piece of paper that used to be one of 2 options. And it doesn't really say much other than, I'll do my best. I'm going to read the documents. Good luck enforcing that. But hopefully, if you listen today and you pay attention and you keep your materials and you take some notes here and there, you'll have some real information that can help your board and make sure that you do what you are supposed to be doing as a newly elected director or a director of 8 million communities for all I care. This class is the other requirement. So this is the first item on this bullet point list. This certificate that you get at the end of this class is going to be valid for up to 4 years. If you stay on for 4+ years, you're going to have to take the class again. Okay, I know that's a pain. I know this is a 3 hours out of your day or whatever it ends up being, but the reality is this is really important so that you can get not only the general information, but as we'll get to in a little bit, the Florida legislature makes massive changes every year over the last few years. So if you were here 4 years ago taking this class, about half of it would have changed between then and now. So it really is important, and I think the legislature got one right this year when they said that this class has to be taken every 4 years. That doesn't matter how long you stay on the board, it's every 4 years. The educational curriculum needs to include certain information. Don't worry, that's all included here. So this class will result, if you stick around long enough, like Jeff mentioned, in a certificate that you'll get once you fill out your survey. Now, someone who doesn't do this within the first 90 days after being elected or appointed to the board is technically suspended from service until they complete this requirement. Now, when I say this requirement, I don't mean just getting the certificate today. I mean also signing the other certificate that, frankly, is a bunch of BS. the board can temporarily fill that vacancy while this person's suspended. And I want to be clear on something. This is not something that the association, the board needs to actively decide. Well, we like Jim, so he gets to stay on even though he didn't do it. And we don't like John, so John is suspended. No, this is a statutory automatic suspension. Now, the good news is anything you do during that time where you didn't realize you weren't in compliance, those votes that the board has taken, the actions the director has taken, they're not invalidated by the fact that you didn't know you weren't in compliance, or even if you did know you weren't in compliance. Bottom line, you guys that are on today, we've got over 200 people from what I saw earlier. The 200 plus of you are doing the right thing, and I'm glad to see that. The other thing that is important here, these documents, the certificate that you get at the end of this class, that needs to be maintained in the official records for at least 5 years after the election of this director. Now, keep in mind, if you take another class 4 years from now, that previous one can probably be discarded, but what does it hurt to have another piece of paper and realistically another PDF scanned in to the association records? I don't see how it makes a difference. So my perspective, just keep it. Keep in mind, condos are required to keep almost all records permanently at this point. Just do the same thing in an HOA. We'll get into records in a little bit, but it's just easier to just not get rid of stuff. Now, there are continuing education requirements. This is being recorded on December 5th, 2024. As of now, there is no one in the entire state that I'm aware of, and we're usually one of the first 4 or 5 that get this kind of authorization. No one is authorized to teach these classes. So you've got a requirement by the end of June of 2025, as of this recording, to do either 4 hours of continuing education that no one can provide right now, or 8 hours if your community has 2,500 lots or more. Now, these requirements exist. We will see in the future how the DBPR decides to enforce or not enforce them based on the fact that it's the same entity that's regulating, and this is a government entity in the state of Florida, that's regulating both the classes being allowed and whether or not people are complying. There's no reporting required. This all just goes in the official records of the association as of now. But bottom line, you do have this obligation, but you can't meet it as of the recording today. So watch out for that. There's a survey, like we said, that will go out at the end of this class. If you want to get onto our mailing list, that is one of the options to check off as part of that survey. And if you want to be kept up to date when we have these classes going on, or more importantly for this discussion, when these classes for the ongoing education are being offered, you're going to want to get on that mailing list.
And Alan, I just will quickly interject. When we know classes have been approved for board member continuing education, it will explicitly say that in our promotional material. So it'll be crystal clear to everybody.
Yeah, we have a ton of classes right now that are authorized for people like Aaron, managers, to take and get credit for it. But as Jeff mentioned, the board member credits have not been given out by DBPR as of yet. And it's a different group authorizing both types of classes. So we don't even know when or whether that's going to happen. So keep online, go on our website at kbrlegal.com and check the calendar every once in a while. And that information will be listed. And I'm sure Access will be providing those as well, either through attorneys or through their own individuals. But moving along, since there's nothing we can do right now, Chapter 720 is the HOA Act. It's this chapter of the Florida statutes that are going to govern every community association that is an HOA, most property owners associations, etc., in Florida. So the purpose of the act, and we won't go through all of these distinctions between HOA versus condo. It's primarily there so you can see the difference between one and the other, but I will go through the HOA things. Okay, there didn't need to be a statute for HOAs. They're a creature of what we call contract. Your declaration is a common law contract between the members and the association, the corporation itself. Okay, so this is another thing some people don't understand. When you are on the board, you're running a business. Whether you thought so or not, whether anyone explained it to you or not, your obligations as a director are to run a business efficiently and effectively and to properly operate and maintain the community that this corporation is running. So when you're a director, you are on the board of a corporation. When you're an officer, you are the president of a corporation. It might be a not-for-profit corporation, and most of them are, but that doesn't mean it's not a business that you're running. So when you make decisions as a director, this is why this is important. You need to be making business decisions, not emotional decisions, not decisions that'll help you more than anyone else, but business decisions. All right, back to the slide. The HOA generally owns the common areas. It's not the owners that own that property, which is why the owners have a right to use it, but not to shove things onto those common areas and plant trees and put benches. That's something the association will generally do. The board decides almost everything regarding material alterations unless the governing documents say otherwise. And even then, there's case law that we'll get into if we have time that kind of works around that member decision. The declaration of covenants and restrictions is not what we call a title document. What that means for your purposes is that those covenants need to be preserved every 30 years or they will expire. And that is a bad thing, in case that wasn't clear. When your covenants expire, they stop being enforceable. That includes the covenant to pay assessments. So the first thing that I do when we bring on a new client within my office, which is in Winter Springs, which is the Orlando area, the first thing we do is pull the governing documents, compile them together, OCR them, bookmark them, have one document that everyone can look through. But most importantly for this discussion, we check and see whether those covenants have expired or not. Because if we can't enforce them, yeah, we can still give guidance to the corporation. The declaration still exists. The association's responsibilities still exist, but the members' responsibility to comply with the covenants might not exist. So the first thing we have done for several communities in the last few months is try and revitalize those covenants, bring them back to life. So it's very important that at every, and we'll get into, you have a legal obligation at the first meeting after the organizational meeting, the first meeting of the board, to look into this issue. And if you can't do it because you don't know how to do it, get guidance from counsel as to when that timeline expires so that you can make sure that you preserve those covenants in the time that you have and not have to spend 10 to 15 grand trying to revitalize instead of maybe 1,000 or 2,000 trying to preserve. Moving on. Again, the statute exists for the sole purpose of giving recognition to corporations that operate these HOAs and providing procedures, practices, and unfortunately, substantive law governing the way that these communities need to operate. We'll get into some of the things that the legislature has done to us and not for us in a little bit. But it's to protect the rights of the members, allegedly without unduly impairing the ability of the association to perform its functions. And that last part is what I have a problem with what the legislature is doing, because these are the expressed purposes of this statute, but the legislature has done nothing, almost nothing, but impair the ability of the association to do what it needs to do and what is contracted for in the declaration over the last few years. So I'll jump off my soapbox and get into contract law. I'm not going to go very long on this, but there is a thing called Kaufman language in this third bullet point that talks about adopting statutes that have changed. So if you have a statute that's amended from 2023 to 2024, and your declaration was recorded way before 2023, sometimes even in the 1980s, 1970s. And your declaration, by the way, is what people refer to as the CC&Rs. Okay, your covenants, conditions, restrictions, easements, whatever. Okay, but it's generally going to be your declaration is what I'll call it. You can think CC&Rs, that's your call. But what needs to be in there in order for certain changes in the law to even apply to your community is this Kaufman language. It needs to say, and almost no HOA declarations say this, by the way, that the declaration is subject to Chapter 720, and this is the magic language, as amended from time to time. Okay, that language might be in your declaration pertaining to certain provisions of the law. It might be in there pertaining to your declaration as amended from time to time. None of that matters for purposes of what I'm talking about right now. If all amendments to the Florida statutes are going to apply to your community, that language needs to pertain to the Florida statutes as a whole, or at least as to Chapter 720 of the Florida statutes. If that language isn't in there, then the association has an argument. Then now we step back to the first two bullet points, that unless the change is procedural in nature, meaning we're going to change the procedure for levying a fine against a lot. Okay, that procedural change of having to have a second meeting, for example. Okay, you have to impanel a fining committee and have a fining committee meeting. That's procedural. It's not you can't levy fines anymore, which would be substantive. Okay, that procedural change will apply regardless of this language. But contract law basically says that the statute that was in place as of the year that the declaration was recorded, meaning the year the contract was made, and this is the original, not all amendments. You'll need to get guidance on that from your counsel, because sometimes it's all amendments, sometimes it's one amendment and not others, blah, blah, blah. But moving on, that statute is in place, and the board and the members have the right to continue enforcing the intended terms of that contract, meaning the statute as of the year that the declaration was recorded, indefinitely, because you have that constitutional right to have that contract continue as is. So if the legislature is changing those contract rights, for example, by saying, I don't care that you've had a provision in your declaration that says no trucks can be parked in the driveway for the last 60 years, now that's not enforceable anymore. Well, I'm sorry, this is not, the example I give is a racial issue where your declaration says no Jews or Black individuals may live in this community. That's something that is going to be eliminated across the board no matter what. But you can't park trucks here? Sorry, but that is a constitutional impairment of a contract. So we have a couple slides, which is why I didn't mind spending a couple minutes on this. But the bottom line is, don't just presume that because a statute is changed, that statutory change, applies to your community. You're going to want to run it by counsel and have them give you an opinion as to whether the statute changes anything for your particular community. Now, the problem with some of this saying that it doesn't apply is that you might have to take that challenge if someone says, but a statute says X, you might have to take that all the way up to the Florida Supreme Court in order to get a ruling as to whether or not this is constitutional. And a lot of communities simply don't want to spend the couple $100,000 to take a case all the way up to the Florida Supreme Court because they want to be able to enforce someone leaving their garbage cans out or not painting their home. Most communities look at it as this isn't worth it. Now, keep in mind, there is a thing called an amicus brief, and there are things called funding methods for litigation. So there may be groups such as, I don't know, maybe CAI, probably not, possibly the CEOMC group, and these are all industry groups, but there might be a group of individuals that are willing to fund your challenge because that challenge will impact the law for the entire state. So I'm not suggesting that this is an automatic that you'll get funded. I will say if anyone wants to take this all the way up to the Florida Supreme Court and spend a couple $100,000, my firm would be happy to help you with it. Moving on. Let's see. So if there's a conflict, Chapter 617, I mentioned not-for-profit corporations. Chapter 617 is the not-for-profit statute. That will apply to most community associations in Florida, including HOAs that are not-for-profit corporations. If you're a for-profit, and I only have 2 of those that I represent that are HOAs, that's going to be a separate chapter at 607. Okay, but Chapter 617 will govern your association. Many attorneys somehow don't even know this, but it is the law. If there are conflicts between those 2 laws, Chapter 720, which is the HOA statute, and 617, which is the not-for-profit statute, Chapter 720 is the more specific statute, and that's usually going to control. Now, the difference is where you have things that look like a conflict, but in reality are not. Those are the ones that you're going to want to run by your attorney. And really, any interpretation of a statute should be run by your attorney. And while Access and many other management firms have really qualified and capable managers, They are mostly, I won't speak for everyone, but they are not licensed by the Florida bar and authorized to give you legal advice. So when you push your manager for legal guidance because you don't want to pay an attorney, they are accurate in responding, I can't give you that answer. So you can yell at them all you want, although I'd recommend against it. But the bottom line is the better managers are the ones that know they're not allowed to give you that answer. So if your manager's telling you, I can't answer that, it doesn't mean they don't know. They might know better than most attorneys in Florida, but they just aren't legally allowed to answer that question without the unauthorized practice of law, which most people in Florida generally try to avoid doing. All right, so the times, and I'll give you an example where this looks like a conflict, but it isn't. We'll get into what a board meeting is and what notices are required, but generally speaking, hopefully you're aware by now, being a director and having been a member of an association for a while, most of those meetings need to be open to the members and they need to be properly noticed, et cetera, et cetera, et cetera. That's under Chapter 720. But Chapter 617 provides that unless the bylaws or articles of incorporation say otherwise, you can have a unanimous written resolution of the board, and that takes the place of a board meeting. And I've heard people say you can't use that because it doesn't entail an open meeting. And my response is, if the statute explicitly says that it replaces that board meeting, you don't need the notice. You don't need the openness. Now, I wouldn't use this for every board decision, but if you've got a pseudo emergency and there's nothing that the members could say that's going to change the board's mind about this decision, for example, hiring a great law firm or a fantastic community management firm, why would you allow the members to interfere with that decision? Okay, so this is something you can use. It appears to be a conflict between the two statutes, but it's not a real conflict. Again, this is something that you'll need an attorney to be able to tell you. Is it not? Which one controls? Or does the declaration, bylaws, or articles of incorporation control? So these are all major issues that you're going to need to run by counsel, and that's why you need to have a legal budget. It can't be, in my opinion, that you have a $500 legal budget for the year. That's a way of guaranteeing that you will screw something up. And I say that whether we work with your community or not, whether you have any interest in working with an attorney in general or not, you need to have an attorney. Moving forward, conflicts between the declaration, articles, and bylaws. Okay, well, these are, again, often visible conflicts that don't really exist. But if there's an actual conflict, just like I said, 720 controls over 617, this is the order of control. The declaration will come first in all matters, period. Okay, the declaration is your constitution of your community. Judges are going to look at that document and presume that everything in there is valid unless there's a case that says you can't have this in your declaration. The articles of incorporation, and by the way, your declaration is here's how you run the day-to-day of your community. Here are the rules, regulations, blah, blah, blah. Articles of incorporation are the document that creates the corporation. They basically say, here's what the corporation exists for, here's where its offices are located, etc. They're the next document in line. The bylaws are going to be your guidebook for how your procedures are going to be run. How do you operate as a whole? Who can be a director? Who can be an officer? How are they elected? How do you budget? Things of that nature are generally going to be what's in the bylaws. Okay, and then finally, you've got, it's not on here, but your rules, regulations, architectural criteria, etc. Now, all of those rules and regulations are going to be scrutinized very closely by a judge because there's a separate test that applies to them that doesn't apply to any of the other three documents. And it goes way beyond just being reasonable. The rules, regulations, articles, architectural criteria, all of that needs to be supported by and not in conflict with what's in these other three documents. So what I've been doing very recently is I've actually created an amendment package that some of our communities are now starting to use because I just created it within the last few weeks, but essentially it will adopt the ability of the association within the declaration. It just adds a provision and says, as to literally anything, and it doesn't say literally anything, but it's everything that I've ever seen in a set of architectural criteria, The board has the authority to govern the size, location, materials, colors, etc., for a laundry list of items. So if you don't have a clear provision that says what the association can govern, but you want to adopt architectural criteria, that's something that you might consider working with your attorney, or if you don't have one or don't like them very much, working with me and my firm on to try and adopt those changes so that you have the ability to govern and create those criteria and have them actually be enforceable. Moving on, membership meetings. So this is where your members get to vote. Okay. A lot of people misconstrue what a board meeting is versus what a member meeting is. And really the only difference between one and the other is who gets to vote at this meeting. At a board meeting, the board gets to vote. At a member meeting, the members get to vote. Who gets to vote on what is almost exclusively decided by what's in your governing documents. So the board is going to make 90% or more of the decisions in your community. Generally, the members are going to vote on amendments. They're going to vote on the election. That's about it. And if they want to make changes to the budget, that's the only things I can think of off the top of my head that the members get to vote on. Literally everything else the board gets to decide. So when you're not having a membership meeting for an issue, don't freak out. Look at your governing documents and see if they say that the members get to vote on that issue. Because if not, it's automatically going to be the board that makes the decision. All right, the annual meeting of the members is generally going to be something that is held with at least 14 days notice, but the bylaws are going to dictate the location, the date, the time. One thing that I've been doing more of recently is amending the bylaws so that it doesn't say on the third Thursday of September at 8 p.m. on the same day and the same time every year. And if it's not on this date at this time, then it has to be the next business day. No, that's super cumbersome. It doesn't work for most communities. So what I'm suggesting is that if you are already working on amendments, add one in. If you've got that type of strict provision in your bylaws, add an amendment that just says it'll be held sometime in September, October, or November at a date, time, and location within X amount of mileage from the community. And that's it. Make it easy. Stop making this difficult. The people that are drafting these documents are making it incredibly difficult for absolutely no reason to follow the bylaws. And then you are asking your attorney and spending money saying, what do I do? And my response is, who's really going to sue you because you had your election a week late? If anyone decides to sue you for that, they have nothing better to do. That's bad legal advice, but it's the advice I have to give. So our job as attorneys is to provide an analysis of risk. It's not you can or can't do something. It's here's the risk you're taking. I would see that as a minimal risk, but why not spend the $1,000 or whatever it is, the 3 to 5 hours of attorney's fees to fix this in your documents? And that's something I advocate. Have an attorney take a look at your entire set of documents and clean that crap up, because provisions like this are rampant in Florida because it's easy for a developer to say, well, you got to have it on the same time, date, and location every year. But they're not responsible, the people that are drafting these documents, not the people that take over after they're drafted and remain on as the developer, but the people that do the initial drafting are almost never responsible for the implementation and the use of that document. All right, moving on. Election is held at or in conjunction with that meeting. So that's your annual meeting. It's basically your election, period, done. You might add things into that meeting, like amendments that you're trying to accomplish because you're already gathering the members together, and that's a logical way of doing it. But all that really needs to be covered at that meeting is the election. Special member meetings are literally any other meeting that's held where the members get to vote throughout the year, done. That's going to be held whenever the board says they want to hold one. For example, you want a mid-year amendment, or when at least 10% of the voting interest of the association petition for it, unless a different percentage is stated in the governing documents. Now, that petition is literally just a document that's signed by a bunch of the members saying, we want to have a meeting for this specific purpose. Annual member meetings do not need to include a description of the purpose for the meeting on the agenda. That doesn't mean you shouldn't do it anyway, because in reality, every meeting in an HOA now has to have an agenda and fairly specific items on the agenda. So why not just make that your across the board rather than think that it's some other meeting that doesn't require this and screw that up instead of screwing this up? If you make it every meeting has to have a specific agenda, that's great. The other thing this does for you as a board is ensure that you can do the business that you are there at the meeting to accomplish, because you're only able to limit speech by the members if you have a written policy, which is one of 8 that I recommend every community have, governing member participation at meetings. So if you don't put on there, you can only speak on items that are on the agenda and only for 3 minutes per agenda item, then you're leaving it open-ended for the members to just have a free-for-all at some point during this annual meeting. Moving on to the special member meetings, again, that does need to have a description of what will be discussed there. And the business to be conducted at that special meeting is absolutely limited to what's on the agenda. The notice needs to provide the date, time, and location of the meeting. If the bylaws don't say when it's going to be sent or how, you need to mail, deliver, or electronically transmit notice to all owners not less than 14 days before the meeting. That electronic transmission is only allowed if the member has opted in to receive notices that way, unless your bylaws are amended to say that's how notice is going to be given, and I have not seen anyone succeed on that amendment. You also need to keep an affidavit saying this 14-day notice was provided in the official records of the association. Again, I just talked about the electronic notice. Those email addresses and fax numbers that the association receives are only official records if they're received for purposes of noticed by the association. So if Access, for example, gets email addresses just to send email blasts that are not official meeting notices and things of that nature for the association, those email addresses are not records that are accessible by a records inspection request. The members are only entitled to the addresses and email addresses that are designated for purposes of providing notice. Broadcast notice, I won't go through because I think there are like 2 communities I've ever worked with that actually use it. That was very prevalent back in the 90s. You would have your community channel where it would be posted. I don't see anyone using that, especially with the prevalence of websites that have been created recently. You do need by January 1st of next year, meaning within less than a month, if you have 100 or more lots in your community, you are going to have an association website. Now, I believe Access is providing that service. I don't know if there's an additional fee associated with that or if it's just really the community portal that was already available that you guys are using. But I know that many management firms, but not all, so that's hint, hint, make sure that you're trying to use one that does offer this service. Because if not, then you're paying a web developer separately and paying for web hosting separately to have this website if you have 100 lots or more. Now, when it comes to the meeting agendas, you have to have the following items posted. Within 14 days before the meeting notice needs to be posted in a conspicuous location on the front page of your website. Okay, no more than 7 days before the agenda and all contracts that are going to be considered at that meeting, or amendments, for example, that are going to be considered at the meeting, need to be posted on the website as well. And again, this all goes on the front page, either on the page itself or a link to a separate notices and agendas page that is for the association only and preferably behind login credentials. The members have the right to attend, and this is what I was getting at with the policy I mentioned. Members have the right to attend and participate by speaking at every member and board meeting regarding every item that's open for discussion and everything that's on the agenda. So, pro tip here, if it's not on the agenda, it's not getting discussed until you close out that meeting. Because if you start discussing something as a board during a meeting, whether it's a member meeting or not, then every single member gets their 3 minutes to discuss that item and ask questions. Now, they get the right to ask questions. That doesn't mean you have to answer those questions, just to be clear. So again, they have at least 3 minutes on each agenda item, and this is only if you have a policy in place that limits their speech. If not, it's not an automatic statutory 3 minutes. I see a lot of communities that should be amending out, listing Robert's Rules of Order. That is their parliamentary procedure. Well, this isn't parliament. We're in America. We're in a community association, in a corporation. This is not a parliamentary meeting. This is a board meeting or a member meeting, period. So get rid of Robert's Rules of Order, or at a minimum, adopt these things that will override the bylaws, these policies. Again, you can adopt these written rules. Member meetings must be held at a location that's accessible to physically handicapped people if they request it. We'll get into a disability policy, which is number 2, which is essentially, here's how we deal with requests by disabled people to be able to use the property, the amenities, and be members of the community in the same way as someone who doesn't have that disability. But that's policy number 2 that I recommend every community have. Part of the reason for that, and we'll skip through the fair housing stuff later because I'm talking about it now. Part of the reason that I think everyone should have that policy is that's one of the questions that the Florida Commission on Human Relations is going to ask you, and that's the organization that governs these issues and will do the investigation of whether there was a violation of fair housing laws if you impact the rights of a disabled person or allegedly impact those rights. But that's on the questionnaire that the investigator is supposed to go through. Does this community or this housing provider, whatever you want to call it, have a policy governing how they deal with disability-related requests? So if you have it, that's a tick in the right direction, and it costs you 2.5 hours of attorney's fees, at least if I'm the one preparing it. It's a flat fee. So to spend that 2.5 hours of attorney's fees to potentially avoid that gigantic attorney's fee to continue fighting that battle of a disability claim or a discrimination claim, I think it's worth it. Okay,
Alan, I'm just going to
soapboxing.
I'm just going to briefly mention, folks,
Yeah.
please don't inundate the Q&A with, can you see me? I am here. I'm logged in. The fact that you have access to the Q&A, can type in the Q&A, that means you're successfully logged in. No need to do that. Sorry for the interruption. Back to you, sir.
No, thank you. Appreciate that, because once we get to the Q&A, I want to actually answer questions and not see, I can't hear you, I can't see you, you're ugly, stop, get off video, whatever. So we're going to move on now. The right to attend these meetings includes the right to videotape. Now, that's another reason why I suggest having this policy in place for member participation, because you will have Karen, no offense to anyone that's named Karen, but all right, let's call him John instead of naming anyone a Karen. You'll have them walking around with their cell phone out, going like this in everyone's face and trying to record and getting in the way and interrupting the meeting. You don't want that interruption. You want to be able to do the business of the meeting and move on and go home and stop dealing with these issues, rather than have to reschedule it because John got in the way and no one could hear and everyone started arguing and it just turned into an uproar. Now, the policy is also going to say that if John causes a problem, that is a violation of the rules. And that's a covenant enforcement issue that the association can then deal with. You might also have a police presence or an attorney present if you think that John's going to cause a problem, to be able to protect the association and continue that business and be able to get things done. When it comes to the annual meeting, or in general for member meetings, unless a lower number is provided in the bylaws, 30% of the total voting interest to the association is a quorum. Now, keep in mind, if you've suspended voting interests, they don't count anymore. So if you have 105 members and you've suspended 5 voting rights, you now have 100 members for purposes of deciding on a quorum and deciding on votes of the association. That can be a double-edged sword, but we'll get into it later. But keep in mind, if those voting rights have been suspended, they don't count for this purpose. Unless otherwise required, a majority of voting interest present in person or by proxy at a meeting at which a quorum of the members has been attained is going to be the deciding factor. Your governing documents will almost always have an obnoxiously high provision of what is required for the members to make any decisions other than the annual election. That's another amendment that I think is probably a good idea to reduce the voting percentage that's required to adopt amendments. Now, one thing, I know we've got a couple developer folks on here. Please, before you finish that turnover, while the developer still has the ability to unilaterally amend the declaration, make it easier to amend those documents. Don't put in a 90, I literally am dealing with one right now. It's 90% for the first 20 years. So basically you're guaranteeing that if the members decide this isn't the way we want our community to run during the first 20 years of its existence, you'll excuse me, but SOL, they can't amend. You're never going to get 90% in an HOA. So anyway, my suggestion is before the developer walks away and turnover's complete, just make it so that at least make it like a majority or 51% of the membership. Even better, make it, 3/4 of a quorum so that it's really easy to make those changes and people can't avoid the ability of the association to do business simply by not showing up. Proxies are allowed to be valid. They need to be dated. And let me take a step back on this. What the heck is a proxy might be the question you're asking in your head. A proxy is basically a document that you use to enable someone to vote on behalf of someone else in an association issue, whether that's an amendment, an election, whatever it may be. To be valid, that needs to be dated, include the date, time, and place of the meeting for which it's given, because these are not power of attorney documents. They're proxies for the purpose of one meeting. It also needs to be signed by the person who executed the proxy. Okay, so this is, again, only valid for the specific meeting for which it's intended. If that meeting is continued, it's valid for another 90 days after that original meeting date. So if you're going to continue a turnover meeting, for example, and I had this come up this week, if you're continuing a turnover meeting, just make sure that the continuation date is before that 90 days is up so that those initial proxies are still valid. Okay, and I've had some continue it twice within that time. Great, give it every opportunity to get all the proxies and all the votes you can. Those proxies are revocable at any time until it's submitted. Okay, so this says at any time, but in reality, once that vote is submitted, it's in, you're done. Any proxy holder can appoint someone else as a substitute proxy. Hey, John gave me his proxy. I can't make it to the meeting. I'm handing it off to you. That's why at the bottom of most proxy forms, it will include, here's my substitute. And then a copy can be used if it's a complete reproduction of the original. Okay, general proxies say vote however you want. Limited proxies say this is how I want you to vote. Generally, both can be used to establish a quorum, but sometimes a general can't be used for the purpose of voting. Electronic voting, I won't get into in detail, but I think it's a good idea. That's a good tool to use if you're having trouble getting people to show up or physically sign a proxy. The good news is that you can now do this electronically, so people can opt in on the association website to electronic voting, meaning they can click through on the vendor's page or on the vendor's app more accurately, and be able to vote without having to sign a piece of paper, put it in an envelope, put a stamp on it, and mail it back, which is apparently too much work for a lot of association members from what I am seeing. So that can now be done electronically. And that once that consent is in, as long as the board has created a resolution that your attorney will usually provide for you at least 14 days before the meeting, that resolution gets signed. Anyone that has opted into electronic voting will be able to vote online on an app, however the vendor provides it. That is not something we provide. I don't believe that's something Access provides. There are specific vendors because this is such a specialized area and there are very strict requirements to ensure that the person that's allegedly voting is actually voting. We don't even try to get into that. And there are vendors that are very good at it. If you don't have a vendor that you've worked with in the past or that your managers work with in the past, feel free to reach out. I don't charge to give recommendations of other vendors. And generally, I don't give recommendations at all. It's just here's who I've worked with that hasn't caused me problems yet. All right, I'm going to skip the rest of electronic voting because we've gone through it. Elections are next. We're going to spend a lot of time on this. The bottom line is if you go by what's in your governing documents, you're doing your elections right. Okay, moving on to the next topic. I mean, it's really that easy. You follow what's in your bylaws to a T and you're done. The problem comes in when your bylaws are not clear. So I've had questions on, we can't impanel a nominating committee. What do we do? Well, your governing documents also say you can take nominations from the floor. What I'm seeing a lot more communities doing of late is simply amending the bylaws to adopt a condo style election because it is so rigid and easy to follow if you do it right. And most managers and most people know how to do a condo style election because unlike in an HOA, it's the same for every condo. So if you want to make it easier, even though it's more work, that's something I'd suggest you consider is adopting that condo style election. Otherwise, you're really looking at your governing documents, doing what they say. And again, it's mostly the bylaws, and whoever gets the most votes wins is really the way that it works. Now, if you don't have enough people that are willing to volunteer for the board, you don't need to have an election unless you're allowing nominations from the floor. And even if you allow nominations from the floor, if by the time those nominations are done, you don't have enough people to have more than, let's say you have a 5-member board and only 5 people have put their names in the proverbial hat, why would you bother counting ballots at that point? Okay, so if you don't allow nominations from the floor, you don't need an election at all at that point. You might still have the meeting, and then you'll have the board organizational meeting afterwards. But if you don't have more people that are willing to serve than spots that are open as of the date of the election, you don't need one. Don't waste your time. Don't waste everyone else's time. Just whoever is on is elected. We call it by acclamation. Okay, now there are specific things that will make a candidate ineligible for directorship. Anyone that's a member is eligible to serve unless otherwise disqualified. So disqualification will be you owe money to the association, whether that is an assessment, a rekeying charge, a fine, doesn't matter what it is. If you owe money to the association on the date that you can last be nominated, and that again is going to be determined by the bylaws. If you have nominations from the floor, the last date you can be nominated is during the election. So if you pay on the date of the election, that might be good enough to make you still eligible. By the way, pay your association. If you're not paying, then you clearly don't care about your neighbors. Whether you've got the money or not, if you don't have the money, figure out a payment plan instead of just ignoring that obligation. Because what you're doing if you don't pay is putting that obligation on all of the other members of your community. And that is the reason that number 3 of policies that you should have is a collection policy. You should be automating that process from start to finish. Your manager just gets to move it forward internally, whatever their process is. And if the funds are not collected by the time that they're done with the notice of late assessment, some will do the intent to lien. If the assessment isn't paid by that time, it just goes to the attorney and the attorney moves it forward, period. There should not be a board meeting needed to decide whether to do collection work. Moving on, someone who's been convicted of a felony in Florida or of an offense that would be a felony if it occurred in Florida and hasn't had their civil rights restored, meaning they're out of prison for at least 5 years, is not eligible to serve. Someone who has pending criminal charges for association-related offenses is also not eligible to serve. You can nominate yourself, and by the way, once those nominations are done, you need to close them out at the meeting. So if you have nominations from the floor at some point, you need to say no more nominations, we're closing it out, and have a vote of the board to do that. Because if you don't, then people can nominate themselves while you're counting the ballots. Similarly, when you finish counting the ballots, or I'm sorry, before you start counting the ballots, close out the balloting so that people can't keep submitting them while you're counting. If there is no one that wants to serve on the board, or if you don't have a sufficient number of people show up at your election, including proxies, the board rolls over. So they just stay there. What I've heard from many people is you haven't had an election in 5 years, and so nothing you've done during that time is valid, and I don't have to pay my assessments, and I'm going to sue the association. Well, there's a legal name for someone that makes that comment. They're an idiot. Okay, they don't know what they're talking about. The bottom line is, the board automatically rolls over because if you couldn't have an election because you don't have enough people show up, then what is the alternative? Every year you're risking being put in receivership? Again, legal term, idiot. Moving along. On election day, we talked about acclamation, the balloting. The members have the right to vote in person or by proxy, unless the governing documents say you cannot vote that way. I hope your governing documents don't say that. Unless the bylaws say otherwise, directors serve a 1-year term. There are plenty of bylaws that'll say that you serve, you have one director that serves a 3-year term, 2 that serve 2-year terms, 2 that serve 1-year terms. Just read your bylaws or have your attorney do so to determine what the terms are. But generally speaking, it's 1 year unless your governing documents say otherwise. Now, when your terms get screwed up because you couldn't have that election because everyone rolled over, reach out to your attorney and they'll tell you how to fix the problem. Election challenges, meaning someone saying that the procedure was wrong for this election, they need to be raised within 60 days or they are waived. And that's 60 days after the election results are announced. So that could be during the meeting. That could be a couple days later if it takes a while to count the ballots. Generally speaking, that's going to be during the meeting. The venue for that election dispute is binding arbitration or with a court of competent jurisdiction, meaning you can file a lawsuit or submit a petition to the DBPR. I would recommend that in all instances, you go to court because the DBPR is that they have some excellent arbitrators and some that are not so excellent. When a judge is dealing with this issue, at least you have a clear appeal process that, someone's going to have to eventually follow the law. And the DBPR arbitrators in some instances has explicitly said, I'm allowed to decide arbitrarily in this case law to support that. In other words, I don't care about precedent. Now, again, that's not all arbitrators, but it's some. And if there's any risk that you're going to end up in front of one of the some, I would say file your lawsuit instead. The election of officers is generally going to be done during that organizational meeting I mentioned. Okay, they're appointed by the board immediately following the election. The directors can't vote by proxy or secret ballot at board meetings, except this one to decide on the officers. As a practical matter, in my experience, 99% of the time, it's who wants to be president. I'll do it. Okay. All in favor? Aye. That's how it's voted. It's not a secret ballot. It doesn't take very long. That organizational meeting is usually 5 minutes. But understand that the board has the authority to do that by secret ballot if they so choose. There's no prohibition against changing officers midterm. What does that mean? Your president is going off and kind of going rogue. Okay, they won't be the president anymore as of the next board meeting because the board can simply vote. And if a majority of a quorum of directors votes and says this person is no longer president, they're now the secretary, or they don't have an officer role at all, that person's no longer president, period. So that is generally the way that I suggest boards correct the issue of one officer that's going off and doing their own thing and making decisions that they don't have the authority to make on behalf of the association, or they're knocking on doors saying you're delinquent in payment of assessments. You need to pay me now. No, that's not how you do that. That's why you have a management company to do it. Question, does the president vote? And since we are a little short on time already, I'll say no, the president doesn't vote on anything unless they are voting as a director. So there's a distinction between directors, which is your board, and officers, which is your president, the mouthpiece of the association, vice president, who gets to kind of do nothing, your treasurer, who, if they have a manager, probably does not very much as well, because they're supposed to manage the money that the management is managing, and the secretary, who generally manages the records, which are also managed by the management company. But those 4 are your officers. They have specific roles designated in the bylaws. They are not directors necessarily. There are plenty of communities that I've worked with where the officers are not also directors. So keep in mind also the criteria for being an officer may be completely different from the criteria for being a director in the bylaws. Fraudulent voting activities, don't do them. That's pretty clear. Please read through this. If I have to actually read this to you, then you shouldn't be on the board in the first place. But bottom line, don't try and force someone to vote in a certain way or change their vote or threaten them to vote in a certain way or try to influence the way that they vote. Those are the items that we're talking about. Don't promise them something if they vote. Okay, it's not a, hey, if you vote me in as president, everyone gets a new TV. I don't care how rich you are, you're not allowed to do that. All right, and then Keep in mind, if any of these activities is done, it is a first-degree misdemeanor in Florida. It's not just you're off the board technically or temporarily. It's you are a criminal if you do these things. Now, you might want to talk to your legislators about decriminalizing these things, because my experience has been that people have been jumping off the board because they don't want to put this at risk. Now, realistically, the crime will not be proven if you didn't do it. Okay. This is knowingly aiding and abetting someone in the commission of fraudulent voting activities, conspiring or confederating with someone to commit voter fraud, all in a community association, or having knowledge of fraudulent elections and giving aid, including by doing nothing about the fraud. Okay. So basically, if you know that one of these things is going on, you need to prosecute the individual. I don't like this, but it does give you an excuse when someone says, oh my God, I can't believe you did this, to say, I didn't do anything wrong and I was not going to be convicted of a misdemeanor and have that on my record just to support you getting in as a director. If there's a vacancy on the board, that gets filled either by the affirmative vote of a majority of remaining directors, meaning appointment, even if there's less than a quorum, or by the sole remaining director, or you can have an election. Now, an election is a process. It takes time. It costs money to send out the mailers. Why would you do that if you don't have to, is my answer. So practically speaking, just appoint someone. And if no one is willing to be appointed, how do you think you're going to find someone through an election? So the appointment is the easier and better way, in my opinion. And that appointment or that new election will last through the term of the director who came off. I've been asked, can we just shift around the terms so that the person that has the most knowledge stays on the longest? And my answer is legally no. Practically speaking, it depends how much you think someone's going to challenge that. All right, moving on to the board. And we're going to move a little faster going forward because I've already gone through a lot of what is in here. But the officers and directors have a fiduciary responsibility to the owners. This is the most important thing you will hear today, period. Okay, this fiduciary responsibility is the most important responsibility in all of Florida. You are the equivalent of a trustee for the association if you are on the board. It's the highest duty imposed by Florida law. Now, the good news for you guys, it's also judged by kind of the dumbest person in the room standard. Okay, you have to have reasonably believed that what you were doing is in the best interest of the association. You have the right to rely on guidance of professionals, including lawyers and managers, in making those decisions. You have the right to say, well, here's why I thought it was a good idea to do this instead of this. But if you are making a decision because you don't like someone, that will almost always get you in trouble, because that will enter into the record at some point. I literally brought up in a case, one of the few that I've done, that I represented an individual instead of the corporate side of these disputes. There was an email that said she did it to me, so I'm doing it to her, in denying an architectural application. You can guess how the judge liked that. Okay, so these are things that you do not want to be responsible for your association screwing up. So make decisions that are based on your best business judgment, so that the business judgment rule protects those decisions. And your insurance, which, by the way, the third most important bill that you will pay throughout the year, in my opinion, is your directors and officers liability insurance policy. Okay, I say it's third because management's first, I'm second. That directors and officers liability policy, and I used to say that jokingly, and I've learned more and more that that order is very, very accurate. But that directors and officers liability insurance policy, if you don't have one, I wouldn't serve on the board, because you're only protected to the extent of the indemnity provision that's listed in your governing documents. Again, directors can't vote by proxy or secret ballot. You also can't vote via email, although you can use email to communicate, and you can use email to not vote on, but somewhat decide certain issues. I won't go into detail about that. You're going to want to run that by your individual counsel for your association. Is it a meeting or not? Well, a meeting of the board, according to Florida law, is where a quorum of the directors gather to conduct association business. So really the answer to this question depends how you define conducting association business. A quorum is clear, gathering is clear. The question is, what is conducting association business? A lot of attorneys, and probably the majority of attorneys in Florida, will tell you that any time that the board is meeting and even discussing association issues is conducting association business. My personal legal opinion that you cannot rely on, because I am not giving anyone legal advice here, but my personal legal opinion is, unless you're making decisions, you are not conducting business. So take that for what it's worth. But there are some attorneys that believe as I do, and many who do not. The question is, how risk averse does your board want to be in making these decisions? At a minimum, if you are going to discuss issues and you re-hold the full discussion at a board meeting, I see nothing done wrong. If you are going to make a decision and then not discuss it because you've already made the decision when you finally reach that board meeting, I think you're probably doing it wrong. Okay. Meeting notices. So a board meeting is not a 14-day notice except in special circumstances. It is a 48-hour notice. Now we'll get into the posting requirements. They're the same as a member meeting, except the time frame is different. So here you are posting that meeting notice in a conspicuous location in the community and on that website if you have to have one, 48 hours in advance, along with the agenda, along with any contracts you're going to consider or amendments or changes in the rules that you're going to consider. If that meeting includes a discussion and voting on either an assessment or on a change to use rights of the parcels, not of the common areas, not general changes to use rights, not just general rules and regulations, but things you can and can't do on your lot, because this is where I see even a lot of attorneys screw up. They think that any rule change requires a 14-day notice. It's only if it's parcel use according to Florida statute. Okay, and again, 14 days if it's an assessment or rules regarding parcel use. Every other board meeting is 48 hours. Some amendments as well if the board gets to vote, but you can discuss those individual meetings with your individual counsel. All right, we talked about this. We talked about this. See, I told you we'd skip through some. Now, just like the members get to participate at member meetings, those exact same rights apply at a board meeting. The only change to the openness requirement for board meetings is that if that meeting pertains to attorney-client privilege discussions or pertains to personnel matters, that meeting can be closed and the members don't get to attend. So if you see that it's a closed meeting with counsel, I don't want someone arguing, oh, all meetings of the board need to be open. No, this one does not. Okay, and the reason for that is if anybody other than those parties that are part of the privilege get to attend that meeting, the privilege is gone. So I literally had an email the other day where a contractor that's helping one of my clients with a problem with an elevator was included on an email, and I said, you got to leave this person off, even though they're on the same side. Okay, they have to be left off. Similarly, that person wouldn't be able to attend that attorney-client privilege meeting. Now, when it comes to personnel, understand this is not your management personnel unless you're hiring them directly. So if you're talking about management issues, that is not a closed meeting unless you're considering a lawsuit regarding management. It's an open meeting unless you are talking about association employees. Okay, moving along. Again, right to attend, right to speak. I would suggest having that policy, and it's the same policy governing member participation at all meetings, whether it's member meetings or board meetings. Oh, unlike the right to speak at member meetings, there's no statutorily prescribed time limit at board meetings. So again, you need to have that policy or people can talk for however long they want. Recording and handicap, we talked about recording, same rules that govern member meetings, same with handicap access. If someone that has a disability asks for special access, you'll generally have to provide it if that disability is served by the access they're requesting. Again, disability policy will guide you through most of those issues. so that you don't have to pay an attorney every time these things come up. Because in reality, again, even though management might be extremely knowledgeable about how to deal with those issues, it really should go to your attorney. Compensation, you cannot compensate your directors. No salary, no compensation for performance of duties as a director, officer, or committee member, or give any other financial benefit from service to the association, except in these limited circumstances. And I'm going to skip through what they are, other than to mention, because I know we've got a few on, a developer or representative serving as a director, officer, or committee member of the association can be compensated by the developer. They do need to announce now once per year at an open meeting that they are compensated by the developer as part of the conflict of interest statutes. So just be aware, if that pertains to the few people I know Aaron has here today, those people are going to have to make that announcement once a year. And that just kicked in this year, so don't think you screwed it up before, but that is a new requirement, and I'm glad you're taking the class and hearing that today. No kickbacks are allowed. Now, if you can't tell what a kickback is, it's basically accepting something in exchange for allowing a vendor to come onto your property, whether it's allowing them to do a presentation, allowing them to sign a contract for services, provide goods to the association, whatever it is. You can't accept anything except food at a business meeting with a value of less than $25 per person, which means that we can go to the ale house, but unfortunately, I can't take anyone that's on your board to Ruth's Chris tomorrow night. The other thing that you can accept is a service or good received in connection with trade fairs or education programs. Now, a lot of times, like, this is an education program. I'm teaching a class. It's education. You're getting credit for it. Doesn't matter whether you're getting credit or not. This is an education program. A trade fair would be, for example, CAI has their annual trade show. CAMU has their annual trade show. The Orlando and all of the other condo and HOA expos are trade shows. So I'm allowed to give away KBR swag during those trade shows. Access can do the same, but I can't just mail you a bunch of free stuff. I can't send you a bottle of bourbon because I think you're a nice guy, even though I would like to, just because there is a risk. And frankly, here's the thing, I can send it to you. You can't accept it, is more accurately stated. If you're on the board of an association that is doing business or might do business with our firm under this law. Now, if I'm sending you a bottle of bourbon and having a business meeting with you to consume that, that might be a little different. I don't know. That might be a workaround. So if you want to drink some bourbon, hit me up. Grounds for immediate removal. If you do any of these things, and a lot of it is the same stuff that we talked about earlier with respect to voting certificates and things like that, you are immediately removed. Now, keep in mind, this is not John said I did this, so I'm off the board. This is, you are actually charged with a criminal offense by a prosecutor. And at that point that you're charged with the criminal offense, you're off the board until there is a finding that you are not guilty or the charges are dropped. Okay, if your term expires before all of that happens, understand your term is over and you're done. Okay, that person that was newly elected to take your spot, that wasn't part of just filling that vacancy, but was an actual election, you're out. And again, this is theft or embezzlement of association funds. Tampering with evidence, meaning you are doing something with the documents so that you don't get caught in a crime. Obstruction of justice, same thing, or any other criminal violation under the HOA Act. So anything that I say today is a crime. If you are prosecuted for it, you're off the board until that prosecution's over. Now, I say until it's over. If you are actually found guilty, that will not get you back onto the board. Sorry. The board fills the vacancy, and if those charges are pending, it doesn't matter that it was pertaining to a different community, you're off. So the people that might be on 10 or 11 boards at once because they're part of an investment group, I'm sorry, but once you're off one, you're off all of them if it's because of one of these things. A director who is more than 90 days delinquent in payment of any obligation, monetary obligation to the association, is also immediately removed and cannot be put back on automatically. That is not a suspension. That is a removal. You have abandoned your seat. Now, once you pay that obligation, that doesn't mean that the remaining directors can't shove you right back on, but it's not an automatic like all the other things we've discussed so far today. Conflicts of interest is essentially where, you've got an interest in a corporation or a business, or you're directly proposing to do business with the association. That's a conflict of interest. Okay. Now, these conflicts need to be disclosed at least 14 days before voting on the issue. What do I mean by that? Basically, before that notice would have had to go out, you need to disclose that conflict to the board. So if your cousin is proposing to be the landscaper for the association and you're on the board, that's a conflict of interest. Conflicts are not automatically bad. So I hate when people sit here and say he had a conflict of interest, they can't sign that contract. That's not how it works. Your cousin might give you the best deal of anyone in the entire state. Great. Thanks for helping the association. Fantastic. You just have to follow these procedures in order for your cousin to give you that great discount. Okay, so again, you give 14 days notice. Let's see. Okay, then the proposed contract must be fully disclosed to the board. And this is the contract and the conflict must be fully disclosed. You need to step away as a director from the discussion and voting, but you can promote the contract first. Okay, so when the board is discussing after that motion's been made, this person that has the conflict leaves the room. And by the way, the fact that a member has a conflict means jack. It means absolutely nothing. It's only the board, because that member is not in a position of power to push the board to make a decision. A director is in a position of power. So if a member has a conflict, I couldn't care less. None of these procedures need to be followed. But if it's a director, again, you step aside and go out of the room during the discussion and voting, and the decision needs to be approved to sign that contract by at least 2/3 of the directors present. So 2/3 of a quorum, less you. Okay, so if you've got a 3-person board, that's going to be difficult. 2/3 is all of them. Moving on. The contract also needs to be reasonable and fair to the association. So you're not just screwing your community in order to get that benefit. And then at the next regular or special member meeting, the existence of the contract must be disclosed to the members. If at that meeting, one of the members says, I don't think this is fair, I don't want it, then a majority vote of the members present at that meeting can vote and say, nope, no contract, we're not doing it. At that point, the members have canceled the contract by vote, and the association is obligated to pay whatever it was that was due through the date of that termination. We're not talking about termination penalties for canceling the contract early. We're not talking about liquidated damages. It's literally the benefits that were received by the association are compensated to that contractor. And the reason for this is there's a presumption that the contractor knew there was a conflict and didn't make sure that the director actually disclosed it and that the proper procedure was followed. We've got different types of committees. I won't go through those because realistically, you're going to ask your manager and your manager can explain that. Finding and use rights suspension committees, architectural committees, and organizing committees are not subject to certain category requirements. These are separate types of committees that are handled differently. Okay, the openness requirements of meetings generally don't apply to HOA committees, but they will apply, and the meeting needs to be properly noticed. It needs to be open. There need to be meeting minutes. If the committee is making a final decision regarding spending association funds, or they are approving or disapproving architectural decisions on a lot. Okay, let me go back to that just for 1 second. When we talk about these groups and we talk about the meeting notice and openness requirements, what we didn't get into is meeting minutes. Okay, meeting minutes should be kept for every meeting. Every single meeting of the board, every meeting of the members, every meeting of these specific types of committees. What I don't want to see is a verbatim typewritten notice of everything that was discussed during the entire meeting. The only thing those meeting minutes should say, to protect the association from prying eyes and whiny people, is here's the motion that was made, or here's the agenda item that was being addressed. Here's the motion that was made. Here's who made it. Here's who seconded it. Here's how every director voted. It either passed or it didn't. That's it. I don't want full discussion. I don't want, well, John had a problem with it and member Jim Smith made this particular comment. No. All you're doing at that point is providing support for someone to challenge that board decision. And your obligation is to the corporation as a director and as the secretary or as the manager. It's not to that individual. Even if that individual is you, that is not your obligation. You have an obligation as a director to protect the corporation. All right, moving along, official records. The official records include a laundry list of crap. I'm going to skip all of this, and here's why. This last bullet right here in italics. All other written records of the association that are not specifically identified, which are related to the operation of the association. What does that mean? Every piece of paper, every document, everything that's in writing that pertains to the operation of the association is an official record, period. So if it has anything to do with the association, you're keeping it, you're making sure your secretary or your manager, as applicable, is getting a copy and that it's being put in your organized official records of the association. Now, you must, this is policy, I think, number 4. You have to have a policy governing official records retention. This is not optional, and you're already late in implementing it and adopting it if you haven't done so already. It was due by July 1st of this year. So if you don't have one, reach out to me and we can work with you on it. If you have an attorney and you like them, reach out to them and they can prepare it for you. But bottom line, you must do this. It is required by Florida law. And this policy is essentially going to say, here's how long and how we will maintain our official records. Here's how and when we will destroy them if it's allowed under Florida law. Now, 99% of your records are going to be kept for 7 years unless the governing documents require a longer time frame. If the governing documents say you need to keep it for a shorter time frame, it's 7 years. Bids that are received by the association for work being performed need to be kept for 1 year. It's not mentioned here, but election-related records are also kept for 1 year. Almost everything else is kept for 7 years. This all needs to go into your written rules governing how you will maintain the records. Now, the other one is going to pertain to what I think is coming next. Okay, well, we'll get into it in a minute, but it's records inspections. People coming in, taking a look at your records, making copies. So I think that's number 5 of what we've mentioned. Okay, records inspections can become a huge pain in the butt when people send out a records inspection request once a week and your manager is on overdrive and overkill trying to comply with these numerous requests when in reality the association has the ability to limit that to once a month. So if you have the ability to limit this, why would you not spend, and for us, it's an hour and a half to 2 hours of attorney's fees. Spend the time. And I can't promise it would be like that for any other office of my firm or any other law office, but that's what we generally charge here. But why would you not spend the time and the money to make sure that you're not spending even more time and money having your manager spend hours and hours that are not compensated by the owner except for up to $20 an hour? And I guarantee you your contract calls for at least double that. Pulling these records, compiling them, getting them together, redacting them to the extent necessary, etc. I dealt with a redaction issue this morning, and it was a 34-page document that was going to take about 12 hours for the manager to redact that was not included in the management contract, so the association's being charged, I think it's $60 an hour. So why not recoup that money from the owner if they're the reason that you have to do this? Anyway, the items that are not to be produced, even though you get a request to inspect them, are attorney-client privilege materials, materials involved in the lease, sale, or other transfer of a parcel. That's usually going to be the application forms that you get and things like that. Driver's licenses, things of that nature. Information obtained in a gated community in connection with guest visits. Social security numbers, driver's license numbers, basically personal identifying information. Now, if that information gets disclosed, it's kind of a no harm, no foul situation. If it wasn't intentional that you gave it up and it just ended up as part of the records inspection request and you didn't individually say, yeah, sure, here's the driver's license for John Smith. That's not going to be something the association's held liable for, but make sure that when you're producing those records, you try and pull that stuff out. Personnel records of the association or management employees, medical records, which you might get either as part of a disability related request or part of a personal injury lawsuit. Electronic security measures used by the association, including passwords, because you don't want people to have access to password protected materials that they're not supposed to have access to. Your software and operating systems, which allow manipulation of data, which is another reason you don't give your passwords out. So this one talks about manipulation of data. What we're saying is you're going to give a PDF printout of what's in QuickBooks and not access to the QuickBooks software where someone can make changes and change your data. Okay, we're giving them copies of access to records. We're saying here's what we have. Now, the other thing to keep in mind, you are not required to create records that never existed just to help somebody out. So if they say we need this list of XYZ and the association never had a reason to create that list, you're giving them the documents that would go into that list as part of the inspection, not creating a list for them. And then the acknowledgments that we'll talk about later. Attorney-client privilege is very important. It's what allows the strategy that's being developed by the association and its counsel for potential or ongoing litigation to stay within the association. And when I say within the association, what I really mean is management, the attorneys, and their law office, and management's entire firm, by the way, not just the individual manager, because you might have supervisors getting involved, et cetera, when something gets really complicated. So it's management, the attorneys, and the board. It's not any individual director unless there's a conflict, meaning the association has an adverse interest or might have an adverse interest to one of the directors or might have an adverse interest to management or the attorney. Those people get to sit in on that meeting and participate in the emails, et cetera. That does not get disclosed to anyone else. It is also not the individual director's right to waive attorney-client privilege by giving away that information to someone outside of that circle of three groups. It is the entire board's decision. I don't get to decide. Aaron and Access don't get to decide. It's just the board as a whole that gets to vote to waive that privilege. That's a crucial distinction that I want everyone to understand. It's not the individual directors or officers that decide this. It's a board vote. Moving on. The association can print and distribute a directory containing the names, lot address, and telephone numbers of every owner. You can also include the email addresses that were provided for purposes of notices and mailing addresses provided for purposes of notices. But again, email addresses and mailing addresses and fax numbers that were only provided for email blasts and the like are not subject to disclosure in a records inspection request. Okay, the owners can also exclude their phone number by asking the association to say, don't put this in the directory, I'm giving it only to you. They cannot exclude the lot address or the information provided for purposes of notices. Now, hopefully the association has already complied with this. If they didn't already, do it now. But by October 1st of this year, every community was obligated to provide either a physical or digital copy of all covenants and rules, meaning your declaration articles, bylaws, rules and regulations, architectural criteria, and policies. That was a mouthful. To every member of the community. Or notice that that stuff is available at no charge on the association website or upon request. Okay, if those rules are amended, the association needs to provide every member with an updated copy of that amended rule, including the original. This is a change from the law from before. Okay, so what you need to say is, here's the new rule and the existing so that you can incorporate. As a result, whenever you're changing rules, my suggestion, it's not that hard. You should have someone that has a Microsoft Word copy of the original. Just adopt an amended and restated set of rules so that you're only looking at one document. Another thing, if you've got 20 amendments, I'm literally working with a community that we just brought in that has over 40 amendments to their declaration, never did an amended and restated. Please, for the love of God, authorize your attorney to do what we call a consolidated declaration. Okay, this is not a member vote, it's a board-only vote because there aren't any changes being made. We're just taking the time to consolidate all of these multiple amendments. And frankly, if you've got more than 5, my opinion is the next one should be done by an amended and restated, or you should be consolidating. But let us put all this stuff together so that when we're reviewing issues for your community and you're reviewing issues for your community, we're only looking at one document instead of 46 or whatever the number may be. It saves so much time. You'll spend a couple hundred to a couple $1,000s up front, and you'll save 20, 30 grand in the first year of legal advice. If you've got a community that's that size and that busy. But anyway, all right, we already talked about this one. Access to official records. You have 10 business days from receipt of a request for official records, and that's to inspect and copy. It's not to send them a copy, email them, fax them a copy of the records. It's you can come into an office located within, 45 miles of the community and take a look at this and copy it if you want within 10 business days. The association does not need to accommodate the owner's schedule. You schedule the inspection for a specific time, date, and location within those 10 business days that'll work for the association. If the owner's not able to make it, sorry. I generally recommend that you provide an alternative day if they say, I can't make it, and try and provide 1 or 2 alternatives, not, well, I can come in on this date. Okay, good for you, but this is the date we're providing. Okay, it's not the association's responsibility to ensure that the date that you provide works for them, at least as of now. If you do not comply with this requirement within the 10 business days, and again, you only need to offer up that time, date, and location that is within 10 business days. If you don't, it's a $50 penalty per calendar day, up to 10 days, starting on the 11th business day. So I call that the $500 gift. No one wants to give a $500 gift except to me. And so I would suggest that you avoid giving that gift. Keep in mind that gift only kicks in if there is a judicial determination that this was intentional, that you didn't comply, or if the request is submitted by certified mail, return receipt requested, and you don't provide it, there is a rebuttable presumption that your failure to comply was intentional. So bottom line, produce those records for inspection within 10 business days. Now, this is, again, one of those policies that I mentioned earlier, everyone should have, in my opinion, is how is this submitted? How is it responded to? What will we do? How will you be able to inspect the records? What are the charges for inspecting and copying? There's no charge for inspections unless we need to redact the records, and we're taking an inordinate amount of time to do that redaction through management or through the attorney. But how are we going to deal with these? All right. If the subpoena and the request for inspection comes from a law enforcement agency, you do only have 5 business days to produce those records to the law enforcement agency. You need to help the law enforcement agency in its investigation to the extent permissible by law. I don't know why the hell this was needed. I don't know who was refusing to give up records to the police or whoever, the prosecutor or whoever was requesting it. But here we are legislating issues that I've never even heard of. So thank you, legislature, for that wonderful addition. Official records crimes, bottom line, it is now a crime to fail to provide access to these records with the intent of causing harm to the association or any member. It is a second-degree misdemeanor if you do it twice or more in a 12-month period. Now, the question is, who's responsible for this? If management has been contracted to produce these records for inspection, how can a director block that effort other than by explicitly telling management, don't provide it? And chances are management is not going to listen to that, because they know what the legal obligations of the association are, and they're going to be smart enough to reach out to counsel and get an opinion that says you must produce this. But if the director is somehow successful, they might be individually responsible. The manager might also be responsible. So that's one reason why management is also going to refuse not to produce that record. Anyone who knowingly or willfully defaces or destroys accounting records that are supposed to be maintained, or creates false accounting records, or defaces or tries not to provide records to get away with a crime, is also committing a third-degree felony or a first-degree misdemeanor, respectively. Bottom line, don't mess with these records. Leave them as is and produce them as required, and you'll be okay. As I mentioned, you can adopt these rules, policies, or what I call them regarding records inspections. What you can't include is requiring any owner to show a proper purpose for the inspection. The proper purpose is I'm a member and I want to view them. That's it. That's all they have to show. There's no reason required. You can't require them to state a reason for the inspection. You can't limit their right to less than 1 8-hour business day per month. Okay, so that's generally what's going to go into this policy is that's the limitation because that's the minimum that you're required to provide to these owners. Now you can charge for copies in excess of 25 pages up to 25 cents per page or whatever a vendor such as FedEx, Kinko's, one of those charges to make the copies for the association. You don't need to give the owner the documents so they can go make copies. You're going to make the copies and make the owner pay for them before they're allowed to come pick them up. Personnel costs can also be charged. And by the way, these also need to be supported by that policy I mentioned, or you can't charge anything. So again, you're going to want that policy in place. Now, the alternative is if you're using a management company and the management contract calls for these charges, then they can be charged as well. But again, when it comes to personnel costs, like I mentioned earlier, that's up to $20 an hour. I don't know of any management company that only charges $20 an hour for that personnel to look through it. Now, you might have some admin looking at it that's not charging quite as much, but most management firms have charges that exceed that 20 an hour. So you're already paying more than you're going to get back from this owner. And again, that's only if they have to go out retrieving and copying the records. It's not just, well, I spent some time on it, so I'm charging. All right, moving on. Oh, and if the member wants to make those copies themselves on their own device or video or capture them on their camera, whatever, or they want them on an electronic copy like a thumb drive, that's free of charge. You can't charge it all, no matter how many pages it is, other than the administrative time if it is an inordinate amount of time. Jeff, you wanted to step in?
Yeah, good time for a little water break for you, Alan.
Good
Just
call.
want to mention, some of you have texted me directly saying, why are you answering some questions and not others? I'm answering any non-attorney related question, technology based, or what does this class count for? Alan is going to touch upon some of the pertinent questions a little bit later, towards the end of the webinar. So I just didn't want you to think you're not being addressed and are being ignored. So we'll address some of the questions, not all of them. There are a lot of you here today, but we'll address some of the questions later. And just remember too, that they should not be too association specific, and keep them on topic and general in nature. And if you're referring to something Alan mentions now, knowing he's going to be addressing this later, try to reference where in the webinar Alan spoke about it so that it rings a bell. Back to you, sir.
Thank you. And by the way, I will be ignoring all questions until the end. So sorry, but you got to stick around if you want answers. Association websites, we touched on a little, but bottom line, as of January 1st of next year, which is less than 30 days away, if you have 100 lots or more, you're going to have that website. You need to set it up. And yes, I did just drink a bunch of coffee real quick. So if I start talking fast, it's partially that. It's partially that we've got a ton of information to still get through today. So I apologize if I'm speaking fast. Again, you'll get these materials after the class is done once you fill out your survey. So one of the requirements of that website is that it needs to be accessible through the internet. Shocking. Needs to contain a sub-page, web portal, or other protected electronic location that the general public can't access, because you've got confidential information that the members are entitled to view, but that the general public is not. Okay, so my suggestion is get all of your records uploaded and online behind these login credentials. Now, in condo land, for some reason, the legislature decided you can just send a response saying everything's on the portal, have at it, have fun. For some reason in an HOA, the legislature decided you still need to provide that records inspection. I would recommend that the association basically say you can come in and we'll print out the copies, and instead of the association having to pull all those documents, if they're scanned in, you can literally have a computer in an office somewhere that someone can use to look at all of the records organized by folders and be done with it. So even if they're being given access to your website that they have at home, and that's the full inspection, that's legally sufficient from my perspective. But anyway, you need to have a username and password. Again, that's going to protect that login credentialed information and access to the protected sections of the website or the app. Now, keep in mind, when we say website or app, you do have two options. I've only heard of 2 or 3 communities in throughout Florida that are using an app instead of a website. That's great. I mean, you can print from a cell phone or a tablet. That's fantastic. But you're in Florida. There are lots of older people here. So the likelihood that everyone is going to be capable of navigating an app and logging in and remembering their credentials and not having to reach out to whoever is creating that website regularly is minimal at best, because that's just the way Florida works. So I would suggest, if you're going to have an app, have it basically mirror what's on the website rather than being the only option that you're providing. So the document posting requirements are almost identical to the records that the members are entitled to request an inspection. So that's why I say it makes no sense to me to not just have everything up on the website that the members are entitled to inspect. That way, again, management just has an easier time, or the secretary, if you're not managed, has an easier time of doing that inspection. It's not, well, let me pull the records you're looking for. It's, well, here are the sections that the members are entitled to view. Have a nice day. And you also, at that point, don't need to worry about anyone messing with those records, because they don't have the capacity to do that if they're only hosted on the website for viewing. All right. So again, I'm not going to worry about this because it's the same things that we talked about earlier. The association does need to ensure that the information that's not accessible to the owners is not posted on the website. Again, that's going to be the things that are subject to those exemptions we talked about: attorney-client privilege materials, etc. You're also going to need to redact anything that you would be redacting in response to a records inspection request before putting those documents online. Now, some people are doing that with a black marker. Some are doing that through Adobe Pro. I don't really care how you do it. You just need to do it before you upload those documents. The association, again, not responsible for disclosing protected or restricted information unless that's made with knowing or intentional disregard of the protected or restricted nature of that information. So these are some protections that, shockingly enough, the legislature has actually put in place for associations. I try and keep that a little quiet because my guess is, as soon as the legislature realizes that they've done that, they're going to pull those right out. Amending the documents is something that we've talked about a couple times today. Generally speaking, if you don't have a clear provision in the governing documents, and by the way, the percentage might be different for each governing document, but if you don't have a clear statement in that individual document, it's 2/3 of the voting interest in the association. Again, if you have suspended voting rights for any lots in your community, those are eliminated. So it's 2/3 of 100 in the example I used earlier, not 2/3 of 105 that need to vote in order to pass that amendment. The format, if that's not being done by your attorney, it's being done wrong, period. So I won't worry about that. Your declaration, and this is another legal issue, but I have to mention it because you might be worried about it, and I hear people complaining about it who have done a very minimal amount of Google research and are Google lawyers. If your governing documents contain that standard provision that says that all lenders must also approve every single amendment to your governing documents, the law changed way back in 2013 that basically said you provide negative notice to those lenders, and only if the change is going to impact the lenders themselves. Okay, if it doesn't impact the lender's rights, you're not going to need to provide any notice. They're not going to need to approve. If the change is going to impact those lenders' rights, and these are people giving mortgages on an individual lot in the community, in case I wasn't clear on what a lender is that we're talking about. Okay, if it's going to impact those lenders' rights, you send a notice out to the lender and say, if within 60 days we don't hear from you saying you object to this amendment, we'll presume that you approve. And under Florida law, that's good enough if you haven't heard back from them within the 60 days. What it does require is that you know who the hell the lenders are. So that might require a title search of every lot in the community if you want to amend those provisions that impact lenders. For that reason, a lot of people just choose not to do it. Okay, and developers cannot exercise their unilateral power of amendment if that amendment would alter the general plan of development. Now, again, I talked about that amendment provision that said 90% of the members need to vote in favor of any amendment for the next 20 years. I don't think that changing that provision, that the unilateral change by the developer would be so substantive to the plan of development that it would be prohibited by this requirement. But that's going to be an individual attorney-client decision as to whether you think that you need the developer's consent, or if it's a unilateral developer amendment, whether the developer is going to try and get the members' consent for that change. Okay. I know that's confusing. It's confusing to most attorneys too, but that's why you rely on attorneys to get this done right. And hopefully you're relying on attorneys who know what they're doing and preferably are board certified in this area of law and have shown that level of dedication. The effective date of any amendment is when it gets recorded. Within 30 days after it's recorded, you need to send out a copy of the amendment to all the members. Now, if you sent a copy before the vote and the version that was recorded is exactly the same as the one that was proposed, then you've already complied with that requirement and you just send a notice with the recording information for the amendment. It can be literally a postcard instead of a copy. Amending leasing restrictions. This is one, and I will say this about several different issues today, but leasing restrictions and sales restrictions is a separate class that we teach that's available on our website. I haven't done it since 2023, and Jeff, please make note that we probably need to do that one again. But that 2023 course, thank you. That 2023 course is already recorded. You can go on kbrlegal.com under the resources tab, and you'll have access to all of our previously recorded classes. This one will be up in the next couple days as well. And I'm sure Access will be sharing it as well. But bottom line, even if not, we will have it probably by Monday or Tuesday on our website so that you can refer back to the video as well as the materials. Now, you won't get credit for any of those classes, but the purpose for board members is not to get credit, it's to get the information. So I'm going to skip through the leasing and sales restrictions so that we can try and get to everything. I'll do the same for a couple other topics. And that's why more than halfway through our time, we're at slide 73. Don't worry, I'm not going to hold you over, and there will be time for probably about 20-30 minutes of Q&A. All right, discriminatory restrictions is another one we do have a class on, but bottom line, I mentioned earlier, if it says that you are you can't live in this community if you're Jewish, Black, whatever race or other category that is a protected class in Florida or federally, effective July 1st, 2021, the board can amend the declaration or whatever restriction exists to pull that language out. And I've been happy to do a couple of those for communities that I've represented. Again, that is not a member vote to remove that language that is frankly racist and disgusting. So anytime that a community wants me to do that, I'm always happy to do it. Doesn't mean I do it for free, but I'm happy to do it. Moving on, these are just some things that the board members should know. Now, I don't think we talk about the Corporate Transparency Act in the slides, but that is one of the government filings that you're going to want to talk to your manager or your attorney about. There was a ruling, I think it was not yesterday, the day before, that might impact that, and I won't get into detail. And if you have no idea what I'm talking about, just write down Corporate Transparency Act and email your attorney and say, do we need to do this? Because the time frame, depending which county you're in, is either the end of this year, if it applies, or it's the end of June of next year. So you're going to want to get on that pretty quickly, at least have a discussion with someone that's knowledgeable in this area of law about whether or not that's something you should be doing, or if you should be holding off, or if it doesn't apply at all. So now that I've thoroughly confused everyone about the Corporate Transparency Act, we talked about meeting minutes. Material alterations is when you're changing something within the community. Generally speaking, only the board gets to vote on those in an HOA. Marketable Record Title Act is what we talked about. Your covenants can expire. You do need to let process servers into your community that are trying to hand deliver lawsuit documents. There are emergency powers that are later in the slides. Yeah, I think we'll get into the rest of this later. The other thing, government filing wise, is a state level requirement. The Division of Corporations in Florida does require a state annual filing. So the fact that you're not for profit doesn't mean you don't have to do this. The fact that you are a not for profit doesn't mean that you get to stay in business forever. There are many HOAs who have had the corporation administratively dissolved by the state of Florida without knowing it because they didn't do this every year. Now, your registered agent or your manager, depending on whether that's the same person, will usually take care of this for the association. I know we do for our clients. I'm 99.9% sure. And Aaron, if you can nod yes or no, I think you guys do it for all of Access's clients. Perfect. Thank you. So this is something that's going to be taken care of, but it's also something that I would suggest you keep on your list and monitor, especially if you're not regularly working with counsel that's your registered agent and you don't have a management firm that you trust. If you're not working with a manager or you think that they're not doing this type of thing, I would check with them to make sure that someone is taking care of this. Sunbiz.org, sunbiz.org is where you're going to want to go to check this annually and make sure it's being taken care of. That's also where I'm going to look when I'm running a conflict check to make sure I have the corporate information for all of our potential clients and anyone that Access is working with that needs just some quick advice to make sure we don't have a conflict. That's the best place to go for corporation related information. It'll also show all of those filing reports year after year. And income tax, again, just because you're a 617 not-for-profit doesn't mean that you might not end up paying taxes anyway. Any money that's left over at the end of the year, and I'm not a tax attorney, I can't give legal advice regarding taxes, but I can say that from my understanding, any money that's left over in the bank account at the end of the year that hasn't been shoved into an official reserve might be taxed. So just keep in mind, just because you're a not-for-profit doesn't mean you have zero tax obligations. All right, we talked about meeting minutes. We talked about material alterations, rules and regulations. We also talked about Marketable Record Title Act. We talked about that 30-year timeline if you do not preserve within those 30 years. And we say it's from the recording of the declaration, by the way, that 30 years starts. In reality, it's as to the sale of each individual lot in the community. But because that would require a title search for every single lot, and we represent some communities that have, 3,000 to 10,000 lots in them, it's not really practical to run a title search for each of those lots. And we just go by the date the declaration was recorded to avoid that obligation to run that title search. So we'll just record it 30 years or less than 30 years from the date that declaration was initially recorded. And that is something that I track for all of the Orlando office's clients. Our firm tracks that for all of our clients overall, by the way. So you will get a reminder when it's, 3 years coming up, 2 years coming up, 1 year coming up, 6 months, etc. And if you screw it up at that point because you chose not to spend the money, then, well, you don't have any covenants anymore. Good luck. Moving on. Talked about process servers. Management. There are some changes in the law. This is not one of them, but it does impact managers. If you have a budget of $100,000 or more, and you have more than 10 units, or I'm sorry, it's an or, not an and. And those are huge distinctions in law. But if you have more than 10 units or an annual budget exceeding $100,000, there are certain tasks that if you have a manager performing them, that manager needs to be licensed. A licensed CAM, period. Okay, now that doesn't mean that every community association in Florida needs to have a licensed CAM, or that every community association that has 10 units or more, or a budget in excess of $100,000 has to have a licensed CAM. But if you have someone that is managing your community and you meet those criteria and they are doing the things that are listed in these sub bullet points, then you must be using a licensed manager. They can do other things that are not these things without having a license, but these are the benefits of using a management firm because there's a licensure requirement for the firm and for the individual managers that are doing the day-to-day. There are professional standards. Your indemnity that's in your management contract might be limited by statute. Rather than go through that, you're going to want to talk to your attorney who will then look at your management contract and see if it's in excess of the indemnity that's allowed to be provided under Florida law. There are emergency powers. I won't go through them because thank God we don't have a hurricane coming right now. But when a natural disaster or a storm, or fortunately over the last few years, the legislature was wise enough to add in states of emergency that might be caused by illness for COVID. Anytime that there is a state of emergency declared for your area, whether that's on a municipal level, meaning city or county, state, federal, whatever it may be, if there is a state of emergency declared, and that's not by your board, just for your community, by the way, because I had someone ask me that a couple years ago. But if there is a state of emergency declared and there is a risk of damage or injury being caused by the issue that is the state of emergency. Now, again, those two need to be connected. It's not just, well, there's a state of emergency, so we can do whatever the heck we want. It's there was a state of emergency declared, and that hurricane that caused the state of emergency, we are concerned is going to cause this damage or injury. These powers will kick in. And I'm not going to go through everything that's included because frankly, that would be a waste of your time, especially since that might not kick in for the next 8-9 months until the next hurricane season. But this is another one. Ask your attorney, what can we do to protect our community when this hurricane hits, or God forbid, another pandemic comes? Bottom line, and I won't get political about it, the fact that there is a state of emergency and it might cause that impact is all that matters. It doesn't matter your political ideology. It doesn't matter how you feel about the state of emergency. It's whether the government declared one. And when that is in place and until it is taken out for your area. So that could be, you get the state of emergency that is just for your area, then you get one that's for the state, then one for the surrounding states. Until all of those are gone, this state of emergency stays in place and these rights exist. So I won't go through what they are, but there's a ton of things you can do while that state of emergency is in place. As soon as it ends, these powers disappear. And what these things are is essentially enabling you to maintain the buildings, maintain your common areas, continue to operate during this state of emergency. All right, moving on to driver's licenses. You cannot swipe a driver's license unless the person whose license it is gives direct consent for the swipe. You're not going to be paying for goods and services with a method other than cash in an HOA. You're not going to be verifying age for age-restricted goods or services, and you're not going to be preventing fraud or criminal activity in financial transactions when you are going through the gate of an HOA. So you are not going to swipe. What you can do is if they consent to the swipe, you can do it, but then you're taking a risk that your security vendor screws that up and demands that they allow it. So what I would suggest instead is either photocopying the ID, taking a photo of the ID, or otherwise writing down the information or typing it into your system, rather than swiping and creating risk for the association. Association debit cards. An association, its officers, directors, employees, and agents cannot use a debit card issued in the name of the association or billed directly to the association to pay association expenses. Any use other than what the statute refers to as a lawful use is a criminal violation. Okay, now there's a really complicated way of getting around this. Use a freaking credit card. The fact that they are putting debit cards as a criminal violation and leaving credit cards open is flabbergasting. But bottom line, the legislature has decided, they decided in, I think, 2018 in condo land that this was a criminal violation. Now it's a criminal violation in HOA land as well. If you have not had the specific expense approved in advance and in meeting minutes that were adopted in advance of you spending the money, or it's directly stated as a line item in the budget that you will spend this money. I've never seen a line item for an individual expenditure, so it makes no sense to me to even include that in the statute and to require that you have the written approval and the meeting minutes. Bottom line, just use a credit card or use a debit card that's in your individual name instead of in the association name, and then ask for a reimbursement. Those are the two ways around this. But bottom line, if you have a debit card in the name of the association, my recommendation is cut that thing up because you don't want to take the risk. It's not worth it. Deposits that are made for any reason that are going to be returned to someone cannot be commingled with other association funds, meaning you don't put those in the same account. If that project is completed, whether it's you were doing construction and the association took a deposit to make sure that any damage caused by the contractor is paid for in advance and just taken out of that deposit, or there's a tenant that's coming in and they might damage association property and that deposit is taken from the tenant. Once that project or that tenancy or whatever it is done, the association has 30 days to return that money upon receiving notice that it's done. Now, what I would recommend Again, I'd prefer it as an amendment to that provision that allows you to collect that deposit. If not, I would make it an official rule and part of the form for requesting the deposit. Put in there who is going to get that money back at the end of the day. Because if you don't have a clear statement that the owner gets that money back, or whoever made the deposit, which is harder to track, gets that money back, or the tenant automatically gets that money back, then you can end up in a situation like I've had some communities get into, where you don't know who is entitled to the money. Both parties are demanding that money from the association, and as a result, your attorney has to file a lawsuit. It's called an interpleader. Put that money in the court registry and then file a motion to get you out of that lawsuit so that neither one of those parties sues you for giving the money to the wrong person. It's a lot quicker and easier, and it will cost you a lot less to put that amendment in place, clarifying who gets it back, or have your manager update that form when the deposit's being made to clarify that issue and avoid the issue altogether. If a member makes a request for an accounting from the association for funds that were deposited, the association must provide that accounting to the member within 7 days after receiving the request. This is litigation authority. So the association can file lawsuits pertaining to anything that's an association interest. That's essentially all of the first bullet point. The other one that I see being used as a sword rather than the shield that it's intended as is if there is a lawsuit involving amounts in controversy that exceed $100,000, the association technically needs to receive the affirmative vote of a majority of the members before you file that lawsuit. Now, what that does not mean is that if the attorney's fees are going to be $200,000 for some major construction defect lawsuit, the association members need to approve it in advance. It's the damages that are all that matters here. The other thing I will bring up, someone who is not a member of the association has zero right to raise this as a defense to a lawsuit. If it is a member of the association that appropriately brings this up in court and is accurate as to, well, they're asking for $120,000 in damages, they didn't get the member vote beforehand, they need to go and get that member vote, the case should be put on hold pursuant to the association's request. You go get the vote, you bring the vote back to court and say, here's the record showing that I've now done what I needed to do, and the case just continues. So the case goes on hold. It shouldn't be dismissed. And if a judge tries to dismiss it, you should be having your attorney explain, and maybe you don't explain to your attorney how to do their job, but bottom line, you might know more than they do. You'd be surprised. There are plenty of real estate attorneys masquerading as community association attorneys, family law attorneys that say, oh yeah, I can handle representing an HOA, and they don't know what they're doing. Architectural control. All right. This is a big one, and this is an amendment, like I said earlier, that I've been working on recently with a couple communities where if your authority to regulate what is being put onto a lot is not in the declaration, you don't have that authority, period. If it's not in the covenants, the association cannot arbitrarily decide, well, we're just going to create board-made rules. That doesn't work. If it's not in the covenants or board-made rules, you can't govern it at all. So that authority needs to be specifically stated or reasonably inferred in the covenants or the architectural guidelines as to the location, size, type, or appearance of something that is going to be constructed on a lot that the board wants the members to have to submit an application and get written approval before they install it. Okay. If the declaration does include those guidelines, or if you've adopted those guidelines in line with what's in the declaration, then the association can't tell someone they can't have something that those guidelines say is permitted in the community. Okay, new law is effective July 1st. If you are going to deny one of those applications for architectural submission, you need to specify why you're denying it. Not only the covenant or the rule or the specific criterion that is being violated by the request, but also the specific aspect of the improvement that doesn't conform. Is it the whole thing is not allowed? Or is it, well, you can do X, Y, and Z, but the roof of this proposed shed doesn't match the roof of the home, and so it's not allowed under our existing guidelines. So you need to be very specific as of this year as to how that response goes. Each owner is entitled to what's in the declaration, meaning you can't ignore those guidelines when approving or denying those applications. They can't be unreasonably infringed, meaning you can't be a jerk about it and decide, I don't like John, so he can't put a shed, even though there's 20 other sheds in the community that are exactly like the one he's proposing. If the association unreasonably does this and denies it, the owner's actually entitled to damages. I don't know what the damages would be for not being allowed to install a shed. Maybe it's storage unit fees. I've never heard of actual damages for not being allowed to install something, but I have seen judges rule against associations that decided someone can't have something that the association had no right to reject. Moving forward. You can't enforce or adopt a rule that limits or places requirements on the interior of a structure, meaning your interior, you're going to subdivide your home and it's not visible from outside the home. It's not impacting the occupancy or anything else regarding the community. You're putting a non-load bearing wall in, or you're putting a central air conditioning system in that doesn't require a unit outside somehow. None of those things are going to be governable by the association. Now, keep in mind, we talked about Kaufman language. My perspective is that all of these architectural change statutes are substantive and will not apply to an association that doesn't have Kaufman language in their documents. That said, again, if you want to spend the $300,000-$400,000 to take this all the way up to the Florida Supreme Court, feel free to call me, because I don't know of many communities that do. Okay, so there's a whole list of things here that the owners can do, even though your covenants say they can't. Bottom line, consult with counsel as to whether that's something that applies to you or not. We've also got the law that came in last year that was modified this year. Anything that is being installed, maintained, or stored on a parcel, on a lot, that is not visible from the frontage or an adjacent parcel, which is what was there. Now we also have, or an adjacent common area or a community golf course, is not something the association gets to regulate anymore. In other words, if you can't see it, you can't tell someone they can't have it. Now, what this doesn't impact is if there is a secondary violation created by this problem. So let's say the association decides we don't have Kaufman language, but we're just going to let this go and adopt the statute as our way of doing business. Or we do have Kaufman language, so we don't have a choice. This statute applies. This doesn't apply to, well, there's a 2-story home next to this one. I can see it from the window of the 2nd story of the adjacent parcel. It's visible from an adjacent parcel. This statute doesn't apply. It also doesn't apply to the secondary violation that I mentioned a moment ago. So if you've got someone who is completely paving their entire backyard, paving is the word I was trying to say there, and as a result, they have major drainage issues because there is no drainage in the backyard anymore, and there starts to be that encroachment of the stormwater on an adjacent lot or on common areas that are behind or adjacent to the lot, or there's flooding in front of the lot. Now, all of a sudden, you've got a secondary violation, and you can force that owner to cure that drainage problem. If the best way to cure that drainage problem is by removing the unapproved pavers, so be it. There's a lot of this that the association can regulate. The association can't. There are certain things that are included here. Artificial turf, like I said, the pavers, boats, flags, vegetable gardens, clothesline, and RVs. If, pardon me, any of these items are visible from any of these areas, this statute is not going to impact your rights at all anyway. So just keep in mind, this isn't you can't regulate these items. It's you can't tell someone they can't do it if you wouldn't be able to see it. As soon as you can see it, this statute doesn't protect them anymore. Flags are another thing that there are certain ones at certain times you have to allow people to fly. The most notable are the U.S. flag, the state flag, military flags, POW, MIA, and first responder flags. This is up to 2 of these, not larger than 4.5 by 6 feet. The owner can also erect a freestanding flagpole up to 20 feet tall and display a US flag and another one of those from the list above. So you might have someone with 4 flags on their property, even though you have a no flags regulation in your documents. My perspective is this is probably something that you don't want to fight, even if you have the right to do so. The likelihood that a judge is going to side with an HOA, that's the big bad HOA with all the power, over the owner that's trying to fly an American flag on their property, I would not want to be the person to take on that case. I will take on most cases. That's not the one I want. Hurricane protection specifications are number, I think, 7 of the policies that every community, I think, should have. This one is statutorily required, and that's basically going to be what types of hurricane protection are and are not allowed in your community. Bottom line, you need to allow people to protect their properties. Seems pretty clear. Vehicle restrictions, we're going to get, and I am going to go a little faster now that we've gotten through the bulk of the material. Now that we're finally halfway through the materials, I know we're running short on time. An owner, guest, or invitee is allowed to park their personal vehicle, even if it's a pickup truck, a work vehicle, or a commercial vehicle, in the driveway or anywhere else in the community that people can park. Now, that doesn't mean, again, we talk about secondary violations. If that's a giant work vehicle, it doesn't mean they can block the view from the corner. It doesn't mean that they can take this 30-foot wide street and put a 12-foot wide vehicle on it so that emergency vehicles can't get through anymore. But it does mean that unless you want to take that chance and fight this issue because you don't have Kaufman language, they are going to be allowed to park these work vehicles, these commercial vehicles on their property, or trucks on their property, unless it is a commercial motor vehicle as defined in the separate statute, which is, I think, 26,000 pounds and 3 axles or more. The likelihood that they're going to try and park a semi, which is really what we're talking about here, on their driveway is minimal. But if you do see someone parking a semi with a trailer on their driveway, I'll be happy to enforce that one. The association can't now prohibit an owner from inviting, hiring, or allowing entry to a contractor just because they're not on a preferred vendor list, or because they don't have a license to perform the work. This one makes 0 sense to me because it's clearly going to impact other people in the community if someone is digging ditches and potentially not doing it right because they don't know what they're doing, they're not licensed. But whatever they're doing, the association is now suddenly not allowed to restrict that. So great job, legislature. Budgets and reserves, I'm going to go through for about 5 minutes, and then I'm going to blitz through the actual material. The most important thing I can tell you about your budget is it's your best guess, period. You are not required to follow that budget penny for penny. Anything that is in operating, you can use for any purpose, for any line item that is in your operating budget, unless it is an officially created reserve, which is a reserve that's created in the declaration, officially created by the developer or voted in by the members. You do not have a reserve. This is an HOA. There's no statutory reserves. I've heard that word before. There's no such thing as statutory reserves for an HOA. And again, there are only specific ways that you can establish officially a reserve. You might be putting money away for something that doesn't make it an official reserve. Okay, so any money that the association has can be used for whatever the association needs. Another thing I want to point out, when you reduce your budget and you keep it as minimal as possible, what you're doing is guaranteeing you won't have enough to do something you need to do. Okay, it is the board's responsibility and management's responsibility in assisting the board to make a budget that meets the operational and management and maintenance needs of the community for the coming year, based on the estimates that you've received, based on the existing contracts and the increases in pricing, etc. It is against your fiduciary responsibility as a director to artificially reduce the reserves. What you're doing there is guaranteeing you don't have enough money. Okay? If the members don't like that you have a high budget, you can propose 2 budgets. One is the one that the board is proposing. That's the one that meets the needs of the community. The other one is the one that the members get to vote on if they don't like your budget. Okay? If you're worried about being reelected, worry about your fiduciary responsibilities first. because I'd much rather not get sued personally, which is what'll happen if you breach that fiduciary responsibility, than end up not on the board next year because I made sure to comply with my responsibilities. Okay, so if you're backing into the budget and choosing not to spend money because it's not in the budget, even though the money is there, or not levying special assessments for things that the association needs, if you are choosing to artificially deflate what the budget includes and not giving the members an accurate picture of what it's really going to cost to maintain and operate that community this year, you are not complying with your fiduciary duty. Okay, and I'm not going to be the one that comes after you, but bottom line, I will tell you, if you ask me, you didn't do what you were supposed to do, and the members would be right to be the ones to come after you. Okay, I'm not going to tell those members that they have a right to do that, but they might find out on their own because there are lots of Google scholars out there. All right, moving into the actual materials, which I'll go through quickly. You do need to prepare the actual budget. You might want to use last year's budget to plan this year's, maybe adopt inflation as your increase for each category. Again, you don't have to restrict how you use operating funds. You only have to restrict how you use reserves, which are completely separate. Operating expenses are, here's what we're going to spend. Reserves are, here's what we're going to put away for the future. It's money that you don't expect to use this year unless that asset that you're reserving money for is expected to fail this year. Okay, if you think you're going to put money away and it's for, here's some examples: pavement resurfacing, repairs or improvements to common areas, association property or common facilities, sidewalk improvements, if the association is responsible for those sidewalks, whatever it is, you're putting money away for future use so that you don't have to have a $2 million assessment in year 15. Okay, that's what a reserve is. There are a couple different ways you can do them. We talked about developer created reserves, membership created reserves. That's a majority of the total voting interests saying we need to put away money for this particular item. Any other reserve, this is the last bullet point here, are not subject to the calculations or restrictions on use of those funds that are in the statute. So once you establish that reserve, you have to use the reserves in a certain way or vote to use them differently. It's not just the board says, I don't like this reserve, we're just going to pull the money out. It doesn't work that way. Calculating them, you basically take how long this asset is expected to last without needing that money, divided by the cost of doing the repairs or replacement that you'll need to do that many years out. Okay, so I'll give you an example, very basic. I'm gonna reserve for the roof. It's $100,000 to replace that roof. We think it'll last another 10 years because it's been a couple years since we replaced it and maintained it. Okay. We've got 10 years left on a $100,000 roof. Guess how much we're saving each year? 10 grand. Done. That's your calculation. That's a straight line reserve. The other option is a pooled reserve where you just kind of shove everything into one group and your reserve is enough for the next component you expect to fail. Okay, so if you've got 10 assets in that pool, then the next one that you expect to need that money, you're saving only the amount that you need for that one. Then you start saving for the next one that's expected to fail. Okay, moving forward, you can change the use, meaning you use those reserve funds for other purposes or pool. If you are shifting from straight line to pooled, you're using the reserves for other purposes, you're deciding not to reserve that year, or you are reserving less that year, you need a majority vote of your members in order to do that. So you can't just pull money out of that reserve and say, this is mine to use for operating expenses now, unless you've got that member vote. Let's see, we talked about this just now. Oh, you can also terminate a reserve. If you have it in the declaration, you amend it out. Whatever is required to amend, that's what you need. If it was adopted by the developer or a member vote, you're going to have, again, a majority of the members, a majority of the total voting interests that are voting in favor of terminating that reserve. Notice and adopting the budget. Again, my opinion is you're providing a 14-day notice. Assessments can't be levied unless notice of the meeting includes a specific statement that assessments will be considered and the nature of the assessment. And by the way, in case this wasn't clear somehow, the budget is how you decide your assessments. So your assessment decision is adopting the budget. That's how you figure out what the assessments are for the year. You just figure out what the proportionate share of that budget is for each lot in your community, and that's what each member has to pay. You can split that by months, quarters, semi-annual or annual. You can't have an assessment every 5 years. You got to fund the budget, but you can split it however you want as long as it's no more, or I'm sorry, no less than annual. By January 1st of next year, the budget needs to be on the website, posted in advance. Before the budget adoption, you can provide the copy, and unless the governing documents require it, you can provide a copy or a statement that the budget is available. Again, that can be just a postcard that goes out to every member saying the budget's been prepared, it's in draft form, it's available for everyone to inspect at no expense if you come in and look at it. But I would consider just sending it out. That way, like an amendment, unless there are changes made to the budget during that budget meeting, which does not require a separate meeting, by the way. But if you're making changes to the budget during that meeting, you would then need to send out the adopted budget as well. So some communities say, I'm just going to send the postcard and then the adopted budget rather than risk having to send it twice. That's up to the board. Let's see. Again, this is something that the draft and adopted budgets go on the website. Assessments and foreclosures, I'm going to skip through because it's something we have a separate class on our website. This one is called Should I Pay or Should I Go? That's one maybe we should put on the list, Jeff, for upcoming, maybe teaching that one, because I think it's been a couple months for that one as well. All right, so we're going to skip through a lot of this, except I am going to go back to this. 14-day notice for any special assessment. 99.9% of special assessments will be adopted by the board, even if the declaration says the members get to vote. Okay, that's one you're going to want to run by your attorney, but based on Florida case law, even if your declaration stupidly says the members get to decide whether the funds are needed, which makes zero sense to me, your board is generally going to be able to adopt that special assessment. Okay, if the membership is approval is required but can't be attained, what does the board do? You amend your budget. Okay, that's it. And then the assessments from that point to the end of the year are going to increase. Now, there are increased limits in some declarations. That's why the board might not be updating and adopting an appropriate budget. Again, amend that junk out, please, so that I don't have to get questioned every year by probably 20 to 30 communities on what do we do? We need to increase our budget, but our declaration limits it to a 3% increase. Just, you need to do what you need to do is my answer. And if someone wants to challenge the budget, let them try and explain to a judge why you shouldn't be able to maintain the community, which they also would have challenged, instead of just having an appropriate budget. Providing an accounting. Now, this is important. Within 15 business days after receipt of a written request for an accounting of what someone owes, the association does need to provide that accounting. Okay, it's basically just a ledger. If that accounting pertains to fines and you don't provide it within the 15 business days, the fine is waived. What I want to be clear on is that if that debt pertains to assessments, those assessments are not waived, period. We've gotten, since this law kicked in July 1st, I've had 5 people tell me they don't have to pay their assessments because the association took 16 business days to get them an account ledger. It does not work that way. Okay, it's only fines that are eliminated by this statute if you don't provide the accounting in time. That doesn't mean you shouldn't provide it in time anyway, but just understand that's the risk you're taking. If you're changing the way of delivering association invoices, you need the members to actually opt into the new delivery method. Otherwise, you might still be required to send it in multiple ways to multiple different lots. I don't understand this. It was an addition to the legislature in 2021, and I have a feeling it was one legislator that just got angry about something because it was the same year, surprisingly enough, that the notice of late assessment became a requirement. And so I have a feeling it was one legislator whose family member got a demand for payment and didn't like the way that the association was doing business, so they pushed this out. Collection of assessments, again, we've got an entire class on a lot of this stuff. So when it comes to the required notices, I don't really have time to go through it for you, but please check out the other classes we've got online. These are really going to be helpful for you to understand collection, covenant enforcement, governing documents, things of that nature. All of this is an important one. If someone owes you money as an owner and they're renting their property, please have your management company or your attorney send a rent demand notice to the tenant saying you have an obligation to pay me until your landlord is up to snuff, because I frequently see associations not being paid by owners because they don't care. And then the tenant gets threatened with an eviction by the association, which is the statutory remedy if they don't pay pursuant to this rent demand. And all of a sudden, the association's getting paid. And because the rent is usually way more than the amount of the assessment, it's usually relatively quick for the association to get paid off. Now, if you've allowed the debt to accumulate to a couple $1,000s before it went to an attorney and is in foreclosure, you're doing it wrong anyway. That collection policy should be in place and should push this forward before then. But regardless of which stage you're at, as long as there's not a foreclosure sale already scheduled, my perspective is if you know this property is being rented, send out the rent demand. And if it's management doing it, I would suggest having the attorney draft a form that management can use whenever the account is not with the attorney for collection, so that you're not paying every single time the association wants the letter sent out, so that management can just prepare it and fill in the blanks with the tenant's information and the property address and all that. All right. Receivership is something you want to avoid. That's about all I can say about that. Financial reporting is basically an obligation of the association to complete certain financial reports. You are a not-for-profit, I mentioned earlier. You have corporate reports, tax reporting that you need. You also need to complete financial reports that are based in depth on the size and dollar figure that your community brings in every year. Now, unfortunately, I don't have time to go through all these, but this is the mo money, mo problems paradigm is what I call it. Depending on what you are bringing in, you will need a higher level of reporting. You may or may not need a CPA. The one that changed this year is that if you have at least 1,000 lots in your community, it doesn't matter what dollar figure you're generating. You are going to need an audited financial statement every single year unless your members vote to have a lower reporting level. Keep in mind also the change that was made is that raising or reducing the reporting level used to be you could do it pretty much indefinitely. Now you can only do it for one consecutive year, meaning if I have an audit requirement and I want to go to a lower reporting level, the members can vote to do that, but they can't do it again next year. They have to wait 1 year before they do it again. So at least every other year, you'll have to get that audit or whatever reporting requirement level you're at. Lowering is the same thing. It's a majority of the voting interest present in a duly called meeting of the members. There are disclosures that need to go into your financial reports if you do not have reserves. Basically, we don't have reserve accounts, and as a result, you're risking having a special assessment to cover those large expenses that come up every so often. Contracts and bids, and yes, I'm breezing through this so that we can get through everything and move on to the Q&A in about 10 more minutes. Contracts need to be in writing if they can't be fully performed or if there is service contract. That's why I will not do work for anyone as an attorney unless we have a written contract that spells out the terms and conditions of our relationship between KBR and the association. Management's going to do the same thing. They won't start working for you until they have that written contract signed. And that makes sense because it's legally required. All written contracts should have certain terms. I want to be abundantly clear here. If you have a written agreement with a vendor that hasn't been reviewed by your attorney, you're probably getting screwed. And I hate to be blunt like that, but bottom line, 99% of agreements that I've ever reviewed, any contracts, and by the way, contractor estimates are even worse because they're not contracts. They're just, here's what I'll try to do. We will prepare, and most attorneys will prepare either an addendum or a written agreement that actually outlines the terms that are not completely one-sided. So if you have a contract, even, I hate to say it with Aaron in the room, but a management contract, you should be running that by your attorney to make sure that the association and not only the vendor is protected by that contract, and that it includes some of these crucial terms. Bidding is only required if the contract is more than 10% of the annual budget, including reserves if you have any. And it's not required if there is no one else in your county that actually offers the service. The other important thing to understand, the lowest bid is not the one you have to accept. Okay, I use the comparison when you're talking about which attorney to hire. You wouldn't hire the cheapest brain surgeon for your crucial work to be done. You should be doing the same thing with all professionals that you're looking to hire. You hire the person that you think, or the company that you think will do the best overall job for your community. We're going to skip some of this. Bulk internet contracts have separate requirements. I'm in the process of reviewing one right now. But bottom line, this is the same thing. If you have the members decide to cancel, you are limited in what the association has to pay to the dollar value that was given up through the date of that cancellation. And that is a cancellation by members. And again, you'll have these slides as long as you submit your survey. So don't worry about me skipping through this. You'll get everything. Transfer fees and estoppel certificates are covered under collection. So I won't go through those. But basically, an estoppel certificate is, here's what you're required to do in order to come clean and bring this account or this property completely up to snuff before this transaction occurs. Usually you're going to get this request when someone is refinancing or someone is selling their lot. A lot of these things I do recommend. I know it's 200 pages of slides. Just read through this stuff after you're done so that you have a better idea of everything in here. I'm giving what I consider the most crucial information, and I know I've gone longer on certain things than others. But bottom line, a lot of this it's available elsewhere, even within our firm. So I would recommend you take the 2-3 hours to watch the 3 classes that I'm recommending. Covenant enforcement is another one. I mean, this is literally, I wrote the book for HOAs on covenant enforcement. So watching that class will give you a lot of information. But that one is covenant enforceability for HOAs and condos. The condo portion is maybe 10 minutes out of the hour. So I would recommend checking that one out. The one thing that I will point out is I think fines are a complete waste of time because they don't actually enforce anything. They just tell someone you did something wrong. Now you owe me money that I'm never going to try and collect from you. So my perspective is either use self-help if the board is comfortable doing that and it's in the declaration, or go forward with seeking an injunction. If you're not willing to do self-help, remove it. Have an amendment that takes that out of the declaration now that there's case law that says if you have that right, you can't get an injunction unless the owner actively blocks it. And again, these are issues that we talk about a lot more in the covenant enforcement class, but due to time constraints, I want to make sure to get to some Q&A, so I'm going to skip a lot of this stuff. Let's see. The important part of what you would need to know is this attorney's fee thing. Okay, when it comes to collecting assessments, there's a statutory automatic right, regardless of what stage you're at, to collect your attorney's fees from the owner. Okay, so if we send one demand, the association is entitled to the attorney's fees for that demand. If it pertains to anything else, including covenant enforcement, unless you've worked with us or a law firm like our firm to amend your declaration to say that the association is entitled to its attorney's fees and costs, regardless of whether a lawsuit is filed, you will not be entitled to that until you get a judgment from a judge. And then you're required to try and collect. Now, I mention this as an important thing because I want to recommend an amendment that makes that cost, the attorney's fees and costs, an assessment against the responsible lot. Okay, what that does for you is ensure that the person or people that are causing that problem actually are responsible for paying the attorney's fees, rather than saying, well, these people are not collectible and we can't collect it. So either we're not going to do the work because we don't want to pay for uncollectible attorney's fees, or we're going to leave it where this person has a judgment against them. We've gotten an order awarding us the attorney's fees, but we're not going to be able to collect from the owner. If you make it an assessment against the lot as part of the declaration, then you guarantee that they're either going to pay or they'll be foreclosed. Okay, moving on. Let's see. Insurance, you need to maintain adequate insurance. What is adequate is something you should probably talk to your insurance agent about. Your manager will generally help you with that if you have one. Flood insurance is highly recommended. 99.9% of the time when there's hurricane damage in a community or in a home, the carrier is going to say, nope, that was flood damage. Your hurricane policy doesn't help you here. So get that flood damage. FEMA provides it, and it's relatively inexpensive compared to all of the other insurance costs you're going to incur. Fidelity coverage is another one you're going to have. Your agent will help you with that. Make sure you know what's actually covered and what is not, because most of the time, if there's an exception, those are the things that are going to go wrong and you won't be covered for So if the insurance policy refers to covered perils, then those items, the policy is worth nothing. Make sure that it includes specific items that are covered as well as general coverage. When you have a claim come in and someone tries to sue the association, 90% of the time, unless the concern is that the insurance cost is going to go up, my guidance is going to be send this to your insurance carrier. Okay, if it's a lawsuit that's being filed or threatened. Because if you can get insurance coverage, you're not paying your attorney their rate to go from start to finish to defend that claim. Now, your deductible may be 25 grand and it may be worth it to just stick with your attorney on that claim. But if your deductible is $2,000, me reviewing that, getting an answer over to the other side and working with you on it for about a month is probably going to exceed that $2,000 deductible. So a lot of times what we'll suggest is submit that claim and we'll stay there as the backup to make sure that the association specific issues involved in the claim are handled adequately by the insurance appointed attorney. And then if the insurance company denies coverage, we're still available and involved to step in and actively defend the claim. Fair Housing Act is yet another course that we have. That's one of the 3 that I would recommend that you have, that you watch the class on. So I'm allowed to skip through a bunch of this and still give you credit. So don't worry. The fact that I'm skipping this material doesn't mean you won't get your certification at the end of the day. But I do have, not a lot of time left, and okay. So I'm going to go through recall very briefly because we're almost at the time where I want to make sure that we get at least 20 minutes of Q&A. Recall is essentially where you're saying, I don't want this person on the board anymore. It's not this person did something wrong. It's not this person is a bad human being. It's literally, I got a majority of the members to vote and say, we want this person off. It does not automatically have to include, here's who I want on instead. You can have a recall followed by an appointment or an election. If you put who is going to replace that person, then keep in mind that if it's on the petition, then the members need to vote not only to remove one person, but also that they are simultaneously agreeing that the new person should be on the board. So you might get less votes, you might get the same amount. Just keep that in mind. But again, this is usually by a petition. It's going to either be a petition of all of a majority of the members, in which case you don't even have to have a meeting to vote. It's just that the recall should be effective if the petition was completed properly, or if at least 10% of the voting interests give notice, then a meeting needs to be scheduled to actually have that basically recall election. Okay, so it's either 10% and you have a meeting, or a majority and they're out. Now, at that meeting that you hold after 10% of the members have signed that petition, it's still a majority of the members that need to vote in favor of the recall. Okay, moving forward, within 5 business days after receipt of the written agreements or adjournment of that membership meeting, the board must notice and hold a board meeting to consider whether or not to certify the recall. This is why you need to immediately get your attorney all of the recall petition documentation as soon as that comes in, because we've had recalls in larger communities where there are 1,000 or more ballots that we need to actually review individually to make sure that they were done properly and decide whether or not legally that recall should be certified by the directors who are being removed. Okay, certification of a recall just means that the person that was supposed to be recalled actually comes off the board. The minutes of that board meeting need to state the time and date of the meeting, the decision of the board, and include a vote count taken for each board member that is sought to be recalled. So if you're not counting some of those ballots, that should be stated in the meeting minutes. And the reason that they were not counted, in my opinion, should also be stated for when inevitably someone files a lawsuit saying you should have pulled that person off the board. What do you mean these ballots are no good? If you're on the members side of this, trying to get the recall accomplished, that's why I also recommend trying to get more than a majority, because if you only get a majority and one ballot was no good, sorry, but you're out of luck. Moving on, I don't want to do too much about recalls because I don't want to deal with them, frankly. I don't like when these come up because they are extremely time consuming. They cost the association a ton of money for no reason, and you could have just waited until the next election. But if it's that urgent, and you have to do it. Keep in mind that no recall will be valid if it's done within 60 days before or after an election. So the fact that you don't like who got elected doesn't mean you can immediately try to recall them. You got to wait the 60 days. All right. Filling vacancies, you're basically going to fill it by the affirmative vote of a majority of the remaining directors, or majority. If a majority or more is being removed, the vacancies can be filled by the members voting in favor of that particular recall. Turnover. This is an important one. Members other than the developer are entitled to elect at least one director if half the parcels in all phases of the community, which will ultimately be operated by the association, have been conveyed to the members. So this is where you are actually voting the members into the board and not just having the developer control the entire community. A full turnover, where at least a majority of the board, meaning member control rather than just one person's on the board, needs to occur at least within any of these events. 3 months after 90% of the parcels in all phases ultimately operated by the HOA have been conveyed to the members, meaning you've sold at least 90% of the lots. Another percentage, whatever it is that's in the declaration, as long as it's less than 90%. The developer abandons or deserts its responsibility to maintain and complete the amenities or infrastructure. Now, there's a rebuttable presumption that that abandonment happened if the developer has unpaid assessments or guarantee amounts for more than 2 years. So this is one that's going to take a while. If the developer files a bankruptcy petition under Chapter 7, now that's not a Chapter 11 or a 13, because I've had that come up. Okay, the statute is specific to Chapter 7. It's just a reorganization. It's just avoiding personal obligations. That is not a complete restructuring. And then if they lose title to the property through foreclosure or a deed in lieu of foreclosure, unless the successor owner accepts developer rights and just takes over that slot, so to speak, or if a receiver is appointed and that receivership is not terminated within 30 days. These are all things that will require the developer to have a majority of the board seats filled by the members. Now, just as a point of clarification, because I had this come up literally this week, and I'm glad that I gave the advice that I did, if you are having that developer turnover meeting to elect a majority of the directors, those developer appointed board members who are resigning should write their resignation letters to guarantee that they will stay on and not have that resignation effective unless the election actually occurs. I had a meeting this week where one person showed up that was actually a member at a turnover election meeting, and we couldn't have the meeting. So if those directors had resigned, you would have no one on the board and require a receivership. You can't just shove those people back on the board. So that resignation notice should be very clear and specific that my resignation is effective on this date, if and only if the turnover actually occurs and new board members are actually placed on the board. The developer can keep at least one director as long as they are holding for sale in the ordinary course of business at least 5% of the lots in all phases. What this means is they're actively marketing those 5%. If they stop trying to sell, then they need to turn over all all director slots. After that turnover occurs, they can exercise the right to vote for their interests, but only in the same manner as any other member, except for purposes of reacquiring control of the HOA or selecting a majority of the board, which they can no longer do once that turnover occurs. Okay, there are a ton of developer obligations after turnover. The people that are here that are not in the not actually members of the developer and are just serving on the board won't need to worry about this, but there's a list of a ton of stuff. And these are all things that we look for when we take over a community post turnover, especially the deeds, the plats, the easements that pertain to the association, which most people don't somehow locate. Here's another continuation of the list. And that is all we've got today. I will close this down and thank you all to those who actually did pay attention. I will shut this down, and Jeff, I know you usually step in when you got something to say, so I'll let you say it.
I appreciate that. Folks, Alan's going to do some Q&A. We won't get to all of them. He'll get to as many as he can. If you haven't already done so, Now is the time to hit that chat button, just so the chat area appears on your Zoom interface. So do that right now, because in about 10 seconds, I'm going to place the link for the evaluation, the required evaluation to get your certificates and the slides in that chat area. So please hit that chat button once so it appears. And I'm about to hit enter. That's the evaluation link. I will go over the process shortly, but first, we're going to turn it back over to Alan and Aaron for some pertinent Q&A.
All right. So any management issues, Aaron, I'm shoving in your face. I'm not touching. But when it comes to the other ones, don't worry, I'll take care of the legal questions. All right, so first question, Chris DeMarcantonio. We are holding our annual meeting 4 days earlier than our documents state, and our attorney's opinion said it wouldn't be an issue. Is this correct? Well, this is something we kind of touched on earlier on. I think it makes more sense to amend that provision so that you have a time range rather than on this time, this date, this location every single year. But I agree, the likelihood of a successful legal challenge, because you held it 4 days early, okay, who's going to even have a problem with that? The directors whose terms might be 4 days shorter than they were supposed to be. If a director has a problem with that, just reschedule it. But I don't see that really being an issue. Let's see, broadcasting on mailboxes, is this acceptable for 52 units? So broadcasting on mailboxes, I don't know what that means. If you mean mailing documents, yes, that's acceptable. If you mean maybe shoving documents into the mailbox, that's not mailing. It's not hand delivery. So I don't know that it would be sufficient. You'd probably be better served by taking a paint stir and a piece of cardboard, handwriting in marker what's going on and shoving it into the ground at the neighborhood entrance. But I don't know what broadcasting on mailboxes means. So if you'd like to email me separate, I think it's Jonice is the way that that's pronounced. Feel free. All right, that one's answered. All notices have to comply with the website posting after January 1st, but not before. Correct. There is no obligation for any association to have a website, Michelle, before January 1st, 2025. So my perspective is, how can the legislature require you to do something if you don't even have to have the website in the first place until then? But on or after January 1st, you will have to comply with all those requirements. My suggestion is, if your meeting is going to be after that date or on that date, comply in advance if you can. Lilium, is the notice requirement after 1/1/25 for meeting and agenda displayed on the association webpage only applicable to communities with more than 100 lots? Yes, but that doesn't mean it's not a good idea for everyone to do it anyway, because frankly, it just makes that more accessible, and frankly, it might reduce the amount of people complaining that they don't know where to look. If you don't have a website and you have less than 100 lots, you don't have to create one for this purpose, is my answer. Is there a mandatory notice or timeline to do so of a vacancy for HOA board members? There's no timeline. It just makes it easier if you have a fully comprised board to actually reach a quorum and make decisions. But there's no timeline. You can do it at the next board meeting. You can do it by written resolution that's unanimous among the remaining directors to appoint a new director, but there's no specific timeline, even if you only have one person on the board. The problem with having one person on the board is you really can't have a quorum at any board meeting. So please clarify what you meant when you said a president cannot vote. I meant that the president, Lawrence, is not a director automatically. You don't vote as president, is what I was saying. You vote as a director, even if you happen to also be the president. So the president, I was trying to clarify the distinction between a director and an officer, which are two different hats that the members might wear or other people might wear. So there are three different hats that most directors will wear. One is you're a member. That's just someone who owns property in the community. Okay, two is you're a director. That's someone who makes motions, votes, seconds motions, and abstains from voting if they have a conflict at a board meeting. Then finally, you've got your officers who do specific things but are completely separate from the responsibilities of the directors, the board. Hopefully that answers that question. Can a board meeting be held by Zoom? We didn't cover this, but bottom line, my suggestion is have all your board meetings via hybrid if you're going to do it that way. That way, if you're doing it as a hybrid where you've got at least one person in a room that's accessible to everyone else, and you have all of your other directors or even all of your directors attending via Zoom, The directors can attend every board meeting if they want via phone or via Zoom without any problems. It's clearly stated in the statute. What's not clearly stated in the statute is that every board meeting can be held via Zoom only. So that's why I say have a hybrid meeting if you want to do it that way. And even if you have, the management office has a conference room available and the manager is sitting in that conference room because they're usually in the office anyway, and all of your directors are attending that meeting via Zoom, that's totally fine. But to have it fully via Zoom only, there's nothing in the statute that says you can do it. That's my only concern. If you adopt bylaws that say you can do it, then you might have at least an argument that that's allowed. Does this cover audio recordings as well as video? So we're talking about recording a meeting. And the answer is yes, Florida's a two-party state when it comes to audio recording, but not when it comes to a board or member meeting where someone has the inherent authority as a member of the community to do that recording. So if you want to require it, some boards will put in that policy regarding member participation at meetings that you can record, but you need to make the announcement in advance or you're going to be booted out of the meeting. I think there's some risk in putting that in there and requiring it, David, but it's something that if you want to avoid that one-way communication, the other way of avoiding that issue, frankly, is saying just understand at the beginning of every board meeting or every member meeting, saying everyone that's here that just chooses to speak needs to understand that there's a risk that any member can be recording this meeting and they're allowed to do so under Florida law. Mark, our documents state directors can be compensated. Congratulations. Whether or not that is allowed, I would run that by your individual attorney. Anastasia says, is Christmas basket, for example, considered a kickback? My opinion is no, but you might have someone who is a little overly zealous that says it is. It depends who it's coming from. Technically, if you've got a vendor that sends you a Christmas basket personally, what I would suggest is bring it into a common room in the association common areas. And now it's no longer a kickback. It's just something that the association gets in exchange for using that vendor. That would be my recommendation. I don't think that you're automatically safe just because it's not a super expensive item. And I wouldn't take the risk that I'm going to be criminally charged to accept a gift basket. Rick asks, what's the retention requirement for emails and other electronic documents? It's the exact same requirement as you would have for all written documents of the association. So it's not different just because those are electronic documents. There are DBPR opinions that emails that have been sent and are official records and need to be maintained that way. I don't know that I agree with that, but if DBPR is going to say it, unfortunately, who the heck am I to say you don't need to comply with what is now Florida law? DBPR generally only governs condos, but there are some issues that it might get involved in HOAs, and I wouldn't be surprised to see someone bringing those DBPR opinions up in court, even though they're not binding on the Florida courts. So just to be safe, I would put those documents in your official records, especially if you're maintaining those records electronically anyway. Official records not accessible to members. Michelle, does or does not apply to the board. The board gets to see everything. It's only the other non-director members that don't get to see certain things. So the board can see whatever's in the official records, unless it is privileged information involving that individual with the attorney. Deborah asks, if you're a board member of 2, do you need to retake this class if the next annual meeting is in 2 weeks, but you're a board member already? No. This class will go for as long as you serve on the board, up to 4 years. So it will be valid for 4 years. You'll need to take it again in 4 years, but the fact that you are staying on the board is what's important. If you come off the board at any time, and I'm not talking about a suspension, I'm talking about physically resigning or being booted or just not renewing, wanting to be on the board, then you'll have to retake the class. But the fact that you are remaining on is what will say you need to stay on. Yes, Jeff.
Hey, Alan, clarify as well. We have people that serve on 2 different HOA boards. They only need to take the class once, correct?
That is my understanding, especially the developer appointed board members. There's a clear statute that specifically says they only need to take 1 class. My opinion is if you get a certificate and it doesn't specify which board you're taking this for, and it's another HOA, then you can use the certificate from this class for any community you're serving on. If you're serving on a condo board, this class will not help you at all.
Right.
Uh,
Thank you,
Bobby,
Stan.
yep, thank you. Bobby asked, can you comment on BOIR required submission by 12/31? That is the thing that I talked about right at the beginning, and this is the Corporate Transparency Act. BOIR is Beneficial Owner Information Registration. Generally, this is the board that's required to submit some personal information. It's a counterterrorism mechanism by the federal government. My suggestion is just reach out to your attorney, because there was a ruling just 2 days ago in Texas in a federal court that some people are saying applies across the board and suspended the operation of this Corporate Transparency Act. And some people are saying, just like the ruling that came out of Arizona a couple months ago, it only applies to the group of plaintiffs. And so if there's any risk, I'm going to take the more conservative approach to say, run it by your attorney, get some written guidance, so that if you do it wrong, you at least have advice of counsel to rely on when someone comes after you and says, you owe this $500 a day penalty that's being levied by the government. Nicholas asks, should be any special form of communication when a handicapped person is attending either for a board or member meeting? I'm thinking providing special accommodation or methods for this person engaged in his or her duty. No, at all. But if that person asks you for an accommodation, that's where that disability policy might kick in, and you will have to evaluate whether that individual is entitled to the accommodation they're asking for. That might be an evaluation you need to do with your attorney. It might be with your manager. But bottom line, if you're willing to provide it, you don't need to evaluate anything. But I would wait, because if you're going to provide this person the accommodation and not offer up an accommodation to someone who is disabled in a different way, get ready for a selective enforcement claim in the near future. So I wouldn't volunteer that, but I would get something requesting that accommodation if you plan to provide it. And then if you choose to provide it, then you don't have to run it up the flagpole to council. Nancy, access to anything on our HOA portal run by our management company can only be accessed using a login and password. So assumption is that no one other than the members can access any of our HOA info, correct? That depends on the security offered by your management company, but generally speaking, they would only, the other people would only access what's on the front page that doesn't require a login. So that's usually going to be just your governing documents, but it would depend on who you're using as a management firm, what security protocols they're using. Nancy, you're a client of mine, and I can't even answer that question right now. So you'd want to check with your management firm is the best answer I can give. Gary asked, why is our HOA not having an election for officers and directors this year? We're not even asked or sent a ballot to see if anyone wanted to submit their name to run for the board. We're told all positions were appointed, so no need to see if anyone else was interested in submitting their name to run. That's something that you'd have to run by your board, because frankly, I don't know the circumstances of your HOA, Gary, but it could be that there was, that there was a recent election that somehow you didn't know about. And the next election isn't coming up for another year. I don't know your circumstances, and unfortunately, you're not giving me enough information. Not that you were wrong or deficient, but what you've written is not enough for me to know how to answer the question. So it just depends on the circumstances. There is the possibility that you're only allowed to have nominations from the floor of the election, and you just had one. So in that instance, you wouldn't have a form saying, if you're interested in serving on the board, please reach out to us. Some communities don't use that condo style election process. Nancy also asks, we have our own internally designed website. Nancy, I'm going to skip this. I hate to say it, but we've got 5 minutes and you and I have already discussed this. So I'm going to skip that one. Michael asks, if your HOA is less than 100 home sites, say 58, are they still required to have a website? No, yet again, there is only a requirement if you have 100 or more lots to have a website at all. So I think this is the 5th question that's the same, and I thought I answered it several times, but I apologize if I didn't. If you are less than 100 lots, you do not have to have a website by January 1st. If our community can't prohibit owners to park in guest spots, I did not say that at all, Edison. What I said is that the legislature says you can't prohibit certain vehicles to park in a driveway. And whether that applies or not depends on your governing documents. But I never said that you can't prohibit owners from parking in guest spots. Unfortunately, I'm not sure where that one came from. What's the reserve funds used for if you have one, whatever the reserve asset is. So this is a physical thing that the association is obligated to maintain. It could be a roof, it could be your stairwells, it could be whatever it is, your clubhouse. But you have a reserve that you're putting away money, Vanessa, for a specific thing to protect that thing, maintain it, repair it, replace it. So that's what it's used for, and only that item or those items. Tony asks, is a budget being voted on required to be sent out at least 14-day notice to the members? Generally speaking, my opinion is yes. Some people will say you only need 48 hours notice. My opinion is this is deciding on assessments and it requires a 14-day notice. Do you need to send out the actual budget? No, you can send a notice stating it's available upon request, but you definitely need to send it either before or after that budget is adopted. Rick asks if the 2025 budget was already presented to the members and approved by the board, but now requires some adjustments. Do these adjustments need to be presented and approved by the member or only by the board? That would be a board-only decision in general. David asks, as the state statute and laws continue to evolve and an HOA may require more legal interpretation or help, should an HOA allocate a certain percentage of their annual budget for legal fees? If so, what might that percentage be? I'd love to say 100%, but the bottom line is yes, absolutely. You should have an attorney that you are comfortable using on a regular basis, even if they're only available like us. When you reach out, we give you legal advice. You only get billed for that. There's no annual fee. There's no monthly minimum. There's no upfront retainer that just gets kept by the firm indefinitely. It's just you need help. We provide it. That's the type of attorney that I would recommend an association like yours use if you're not used to using an attorney. And that is, these are all things our firm offers. But what should you allocate a certain percentage? No, you need to allocate a reasonable dollar figure regardless of what your overall budget is. And depending on how many questions you intend to ask, that'll determine what your budget is based on the hourly rate of the attorney you're working with. So, if you'd like to give me a list, David, email me a list of items that you think you want to discuss with an attorney. I can give you an estimate. That's the best I can do right now. We've got 2 minutes left. I'm going to do 2 more questions. Oh my goodness, I got to skip because Michael Bender asked a question, and I am in absolute shock that my partner is
It's not the same guy.
Oh,
He's got a named doppelganger out there,
okay. Well,
a
I'm going to
named
answer
twin.
anyway because you know what? His name's on my shirt. I have to answer the question, whether it's the right Michael Bender or not. For property owners disruptive to board meetings. Oh, this is already going to be a good question. I can tell. Thank you, Michael Bender. If they're disruptive to board meetings and at every board meeting, they desire to address each item using their 3-minute time limit, but they don't address the specific item, but instead they ramble, what can you do? Can they be suspended permanently from participating? No. My suggestion is have a police officer and your attorney present at every meeting until this person cuts the crap. Adopt the member participation at meetings policy that I talked about earlier. Make sure that it addresses this behavior and says, if a member refuses to stay on topic while agenda items are being discussed, their time to speak will be terminated. And if they refuse to cease speaking when directed to do so by the board, they will be physically removed by police from the meeting. And then the association will also treat that as a rule violation and potentially file an injunction lawsuit against that owner to prevent them from continuing to do this, so that continuing to stop the association from being able to operate will also mean that they are breaching a court order. Now that it's 1 o'clock, I will shut up. And Michael Bender, thank you for attending. Sorry to anyone I didn't get to. You're all welcome to shoot me an email. It's as@kbrlegal.com. And I will not promise to get back to you today, but usually I'm pretty good about, even for non-clients, getting back to people within a day or two. So again, as@kbrlegal.com is the best place to find me other than LinkedIn. Feel welcome to follow me. I only post things that are either funny to me and not to anyone else, or that pertain to community association operations. Thank you again to Access. And of course, Jeff, as always, great working with you, my friend. And, Aaron, especially, thank you for setting this up for us and taking the time to show up at kind of last minute notice. And you did a great job. Your nods were very helpful and much appreciated. And if there's anything that anyone needs, you know where to find me now.
Thank you all. It was our pleasure for sure.
Well, thank you both.